Ms. Basso about another matter, if you wouldn't mind. Man, here's this.
Alton Beach and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right. Ms. Reed?
Hi, good morning.
Thank you,
Good
Judge.
morning. Thank you, Mr. Patel. Do you have a case?
I'm actually covering for Mr. Cotton.
Okay.
He's got, I believe, Felicia Ward on the docket. I believe that's with Ms. Basso.
Yes, 2019 CF 1323.
Yes, Your Honor. And my understanding is that Ms. Basso has offered, has made an offer, and this case will be a plea. What the holdup is right now is that Dr. McDonald is doing a report. She's handled the treatment side and should be providing the report and recommendation that is required by statute. So he's asking, I guess, to pass it to another court date.
It was a fairly uncomplicated plea, but this is the second time that we're passing it, so it does need to be the last time, please.
I
Third
will let
time.
him
This
know.
is the third
Okay.
time.
Third
Okay,
time.
I will let Mr. Cotton know that it needs to, that no more continuances.
So I've got it down to set an evidentiary hearing, but you said that this is going to be resolved?
Yeah, my notes say that the offer was reinstated with a modification to 1 year CC, and it will be a plea.
Right, so I don't know why we keep continuing it. It's pretty simple.
Where is Ms. Ward?
I believe there's a waiver of appearance on file, Your Honor,
Okay.
and that would be something you can talk to Mr. Cotton. I'm just.
Right, I haven't heard from him on it. I thought we had it resolved last time. That was my concern.
Oh, I'll let him know.
Please. I'm not objecting to the continuance, ma'am, but like I said, this offer went out at the end of January. I thought we had it resolved last time, and it was continued.
Thank you. So we will schedule the case for April 21st at 9. That will be the last continuance. So
Understood.
either it needs to be a plea or an evidentiary hearing
Okay,
on that day.
okay, so that will be plea or evidentiary hearing.
Yes, so Ms. Basso, if you need to have the probation officer present,
I can do that now.
okay.
All right.
That's April 21st, 9 o'clock.
Oh, April 21st, okay, April 21st.
Yes.
Okay, I got it. I will relay to Mr. Cotton. That's all I have. May I be excused?
Yes, thank
Okay,
you.
thank you, Judge.
Thank you. Ms. Matthews?
Yes, Your Honor.
Come on up.
Good morning, Judge.
Good morning.
I think we were just going to pass it. I was speaking with Ms. Gaynor with the state, and we're working on getting in contact with the victim here today. I think there's been some contact. We might be able to get a hold of her today.
So
and
you want to
resolve
pass
this.
for a little while?
If that's okay. Your
Sure,
Honor.
just let me know whenever you're ready.
Okay, thank you.
Okay, thank you. I don't see Mr. Nopes present. Is Stephanie Berryhill present? That's 25 CF 1008. Do I have Dawn Byers present? Dawn Byers, come on up, ma'am. This is 23 CF 341 and 22 CF 1606. Are you Miss Byers?
Yes, ma'am.
All right, thank you. So you're here on allegations that you violated your probation in 22 CF 1606 and 23 CF 341. And I saw that you don't have an attorney. Would you like me to appoint one for you?
Sure.
All right, I'm appointing the Office of the Public Defender on both cases.
Your Honor, Steve Medina for Ms. Byers. I'm handing her my card, with my assistant's name on it. Does the state have an offer? Don't say anything.
It would be to adjudicate, it looks like it's a failure to pay type of situation. If she were to pay by the next court date, it would be a situation where we could dismiss the VOP. If all costs and everything are paid by then, other than that, it's an adjudication, cost to a lien, and I believe she was adjudicated prior to her time served.
And would the state, I mean, Your Honor, could we potentially just do a continuance? And how much are we talking about?
I'm not exactly sure how much.
I'll look on the affidavit.
But I have no objection to a continuance, especially for her to speak with counsel.
So according to the violation report filed on January 30th, and I'm looking in 22 CF 1606, there are 4 allegations. The first one is failing to pay court costs in the amount of $673, and looks like, I believe $25 has been paid on that, leaving the balance of $673 as of January 28th. I'm not sure which case that's in. Then allegation number 2 is also court costs. It was $250. Those were imposed on April 17th, 2023. It was a VOP, cost of prosecution and cost of defense fee. So those are still outstanding as of January 28th. Then the third allegation is another $250 in court costs, which were imposed on May 21st, 2024. Same thing, VOP, cost of prosecution, and cost of defense. Then the fourth allegation is failing to do community service, 100 hours, and those had not been completed as of January 28th, 2026. Those are the allegations.
Your Honors, I think Ms. Byers would possibly end up wanting to decline the public defender to save herself a little bit of money and ask for a 2 or 3 month continuance if that's possible. Just as a friend of the court.
Okay, well,
If you change your mind. Your
I
Honor,
will-
may I, Judge?
Yeah.
I think that she advises community service, she advises that costs of supervision were waived. So, and Your Honor did not mention cost of supervision, so I'm just telling her, focus on the court costs and the community service. That seems to be what this is about.
that is what it's about. It's just court costs and community service hours. So there's no cost of supervision alleged in the affidavit.
Okay.
So, what's the plan? So, ma'am, how many hours, or let me ask Ms. Officer Varese, how many hours have been completed? I couldn't.
I haven't turned anything into probation for community service yet.
Okay,
So they don't have any record of anything completed.
okay. What's your plan to get it done?
To have it completed, and I was just double checking that there was no cost of supervision, because I was told that I had to pay cost of supervision to my probation officer, and I was under the assumption that the fees for probation were waived.
There's no allegation in the affidavit for cost of supervision. It's only court costs.
Okay.
And
All right.
community service. So, have you done any of the community service yet?
I have, and I
Okay.
have a record of it at home.
Okay. So do you have a plan to get it completed?
Yes.
Okay. All right. So what I'll do is continue the case, both cases, to April 21st at 9 o'clock. So do you want me to not appoint the public defender today?
Yes.
Okay, I'm vacating that appointment of the public defender's office. If you change your mind, if you want an attorney at any time, you can just write a letter and file it with the clerk. Make sure the case numbers are on there, and it'll get to me, and then I can appoint an attorney prior to your next court date.
Okay.
Or we can do it then if you wish.
All right.
So you have the right to have a lawyer represent you, and if you can't afford one, I'll appoint one at any time.
Okay.
So April 21st at 9 o'clock on both cases, 23 CF 341 and 22 CF 1606. Let's see where we are as far as your community service. Turn in whatever you have,
Okay.
and then I'm sure you'll get to work on that, and then see how much progress you've made between now and then.
Okay.
Your Honor, any court costs that are applicable to be paid via community service, the state would have no objection to her going that route as well.
Okay, so some of the costs might be eligible to be worked off with community service. You'd have to check with the clerk to see if any of your costs are eligible for that.
Okay.
So you could do extra community service to work off those costs. You can also buy out the community service hours if you wish, but let me see what Officer Varese has to say.
We will not be supervising her after 4/16, that is when she's completed, so.
Okay. Thank you.
I'll make
So-
sure I have everything done in that time frame.
Okay, so if you want to buy out your community service hours, you can do that as well.
Okay.
And talk to your probation officer about that, but
Okay.
I'm fine with you doing that too.
All right.
Okay, April 21st at 9 o'clock.
Okay.
All right.
Thank
There
you.
might be something up there you can write down your court date.
I have a piece of paper right now, and I'll write down.
Okay, April 21st, 9 o'clock. Thank you, ma'am. Okay. Do I have Jenny Aravando present? This is 2018 CF 310. Yes, ma'am. Are you Miss Jenny Aravando?
Yes, ma'am.
All right, great, thank you. And you're here on allegations that you violated your probation. Let me just get to that paperwork. I believe it's just financial issues, cost of supervision and court costs. And let me pull up the affidavit. So I see an affidavit that was filed on February 3rd, 2026, and it contains 2 allegations. The first one is failing to pay cost of supervision, and as of February 2nd, 2026, you were in arrears in the amount of $2,145.44. And then the second allegation is court costs, and your balance as of February 2nd, 2026 was $250.01. You have the right to have a lawyer represent you. If you cannot afford a lawyer, I'll appoint one for you.
Well, what I was kind of hoping would happen, I've paid $50 towards a court cost, and then I got injured at work, so I have a whole workman's comp case.
Okay.
So my hours got cut at work because I got injured. I've paid everything else off but that.
Okay.
The supervision fees and the court costs.
Okay.
And that's for the last VOP I had, the court cost, that's 200 left. But she told me it was 150 that was left.
I don't know. I'm just looking at the affidavit that was filed on February 3rd. And as of February 2nd, this affidavit says you owed $250.01. But let me check with Madam Clerk. The clerk shows $330 is owing in court costs, so I'm not sure if Officer Varese can look and.
I see a payment of $933,
Oh,
but it doesn't look like that it was down to your clerk here, so.
Okay.
My apologies, we're switching over systems, and I have to look at 2.
oh, that's no problem. How much was paid on March 3rd?
It was $50,
Okay.
but minus the surcharge, so it's actually $48.08.
Okay. I'm not sure why the affidavit says 250.01, but the clerk shows 330. I don't know where the difference, or what the difference is. So, ma'am, would you like me to appoint a lawyer for you? Okay, I'm appointing the Office of the Public Defender. And I have Mr. Koch present.
Okay. case, Your Honor. Can I have just a brief moment?
Sure.
Your Honor.
Sure.
If I may ask, is there a current offer this morning for the violation of probation?
Can I speak to you one moment?
Yes.
I'm sorry, Your Honor.
No problem.
Thank you, Judge. Time.
Sure.
Just getting up to speed on this case, Your Honor. It looks like costs are what's holding it up. If possible, can I ask this court, could we waive all costs of supervision? That would leave roughly around $200 left. And
Well, I think the clerk might show a different amount, but does the state have any objection?
No, Your Honor, the state has no objection, and if cost of supervision is waived, then by the next court date, she terminates on the 21st of April, which is our next miscellaneous. So by that point, if she's paid off the remainder, the state would just dismiss the violation of probation and let it terminate.
Does probation have any objection to waiving the arrears and the cost of supervision? No objection. Cost of supervision arrears are waived and ongoing too for the next month or however long you have. So that saves you quite a bit of money right there. But you do need to pay off your court costs. Now, again, the clerk's office records show something different than what probation's affidavit says. So I don't know where the discrepancy is, but I would.
Can I get a printout of it?
You probably have to go down the hall downstairs. Do that today. You can just walk down into the clerk's office and ask them, and they should be able to give you that so you can sort it out. But whatever it is, it is. So according to the clerk. So let me just make a note. What we'll do is continue your case to April 21st at 9. So that gives you a little more than a month to get the costs sorted out. And you heard the state, you know, if everything's taken care of by then, they'll just dismiss the violation. And so, all right, April 21st at 9 o'clock. All right.
excellent. Thank you, Judge.
Thank you. Is Heather Johnson present? 23 CF 2801 and 24 CF 2241. Heather Johnson? Justin Shear. Is Justin Shear present? 2017 CF 1831, 2019 CF 2444, and 2021 CF 1843. Yes, sir. Are you Justin Shear?
Yes, ma'am.
I'm Judge Clark. Let me get your paperwork. All right, you're here on a request for early termination of probation.
Yes, ma'am.
And is there any objection from the state or the probation officer?
Your Honor, the state does object to the early termination. There were 3 violations of probation throughout Mr. Shear's term of probation. The first one was in 2019. There was a new law violation. 2021, another new law violation. And then 2023, there were technicals. And Your Honor, for that reason, the state objects to the early term.
And what is probation's position?
I do not object, but I will be the same.
And the motion says your termination date is scheduled for May 4th, 2026?
Yes, ma'am.
Okay, is that correct, Officer Varese? I just want to confirm that. Yes. And I've got 3 case numbers, and if you need them, just let me know.
Yes, I have 5/4/2026 is the termination.
Okay. So you have about
48 days.
48 days left.
Yes, ma'am.
Okay. Officer Varese, I see that there was a new term well, I'm trying to find it, but I think there was a new term started in 2022, possibly.
5/05/2022.
Okay. Have there been any violations since that? I know Ms. Giardina mentioned something in 2023, and I do see an affidavit filed, but I don't see,
Ma'am, in 2023, it was a modification from one rehab to another.
I do see an order modifying, and then I'm not sure what happened other than okay, I'm looking at the clerk's notes from February 28th, 2023, and it says There was no VOP, case should be closed. And then that's when the modification regarding Jada House was entered. Let me look at one of the other cases. I was looking at the 2017 case. There was. Okay. I don't see the resolution. I mean, I see the modification, or the order of modification, but I don't see the resolution of the VOP other than what is in the clerk's minutes that says, says order in case already, there was no VOP, case should be closed. That's what the clerk's minutes say. Obviously, I wasn't the judge at that time, so I don't know what happened. So I'm just trying to piece it together. Yes.
At the time, my lawyer was Burt Moore. He just started his year being barred. I had the state attorney stand up here with me during that time, and we just said that there's no VOP. We're just going to do a modification. All things are still set. Nothing different besides the probation.
Ms. Basso, I believe you were assigned to the 2021 case?
Yes, ma'am, we were just reviewing that, and
Oh.
it was an order of, it was a modification of probation, so there was a VOP on that.
Okay. Do you show that all of the costs have been paid in all three cases?
CF 1843 has a zero balance. CF 2444 has a zero balance. CF 1831 has a zero balance.
And Officer Varese, I know I'm running you in a million different directions, I'm sorry. Do you show that all of the other requirements, like community service, any other terms and conditions have been completed?
Yes, Your Honor, he looks like he has completed other than community service hours and looks like check on fees, but everything else looks.
Thank you. I'm just filling out some paperwork, sir.
Yes, ma'am.
Yes, all fees and costs also have been.
Thank you. Sir, ordinarily I wouldn't grant a motion for early termination when there's been a violation.
Yes, ma'am.
I have reviewed, I looked at your cases last night, and then I've looked at them again today, and it was hard to tell about the possible violation in February of 2023. It looks like there was a modification at that time regarding your residential treatment. Since that time, you have paid everything, you've done everything, you've had no violations. Looks like you had a rocky start back in 2017 for a few years, but for the past, from what I can tell, the past 3 years, you've been a model probationer. And the court appreciates that very much. You're almost finished. You said 40, or
48 days.
48 days. The court's going to terminate your probation today.
Thank you.
So you don't have to have those 48 days on probation. And I filled out an order that says your probation is successfully terminated, effective immediately.
Okay.
Good luck to you, sir. Thank you for taking probation seriously these past 3 years.
Yeah, thank you.
Thank you. Thank you.
And not that it matters anymore, because he's already gone and it's done, but I did find his violation because it was on another case, somehow I didn't get the rest of them.
Thank you. I think I saw Mr. Nopes. Mr. Nopes, are you ready to call your cases? All right. In 10 minutes, I'm going to have to take the jail, just letting you know they're on Zoom.
Judge, I think the first case I've got is John Burkos.
Okay, I believe he's an inmate.
Judge, I don't know what the state's,
The local deputy that's back there, he's basically working in the courtroom right across the street. He's just gonna be a couple minutes. Inmate is here, we just can't get him out.
Okay.
and then the other case I've got is Pamela Henson, 25 CF 2466.
I believe she's also an inmate.
She's almost empty, so I'll sit right here and just, I got other things I can look at.
Yeah, I'll go ahead and take the jail on Zoom. Mr. Medina, is that okay?
Yes, Your Honor, we can take them now if that's the court's preference.
I think they are
They're ready.
ready, so let me get them on.
And I can say that, well, when he comes on, I can say more, but Davis, it sounds like we're gonna be able to work it out, but because we just, the terms were just discussed by the lawyers, I haven't been able to write it up and get it to the jail. So
Okay.
we can't have him sign it right this moment, but
Okay. Good morning, everybody at the jail. Thank you for accommodating the 2 inmates on Zoom this morning.
Morning, Your Honor. It's no problem.
we've got, Your Honor, Carasso and Davis in any order that's convenient. They both have medical issues.
Whatever's convenient for the jail.
We have Mr. Preston Davis first.
All right, let me
Thank
get
you.
to him. Okay, he has case numbers 23 CF 199, 25 CF 522, and 25 CF 524.
Your Honor, they're probably pulling
getting
him
him.
in. Oh, he's standing up, good.
All right, there is Mr. Davis. Good morning, Mr. Davis.
Your Honor, Steve Medina for Mr. Preston Davis. Mr. Davis, I'm here and you're there because we thought it would be better for your health to not have to transport. Your Honor, I have an offer from the state that would be allowing him to get out of custody today. it would be a reinstate and modify and add 3 years probation. He was already doing 2 years CC when he allegedly violated. The states had been taking the position that it wanted to execute the 10-year suspended sentence, but basically because of the special circumstances relating to his health conditions and the jail medical evaluation that we forwarded to Your Honor yesterday, the state is willing to make a special accommodation to reinstate and modify to add 3 years probation. Because it is a reinstate and modify, I technically don't have to have it written up as a VOP or VOCC agreement, but I know Your Honor likes that so that I can go over it with him. I can try, if we want to bring him back later this morning, I can try to type it up and send it to the jail and have him sign it. I'm just not there and here at the same time, but we can work it out, get him out of jail, which I know he wants to do.
So, Mr. Davis?
Yes, ma'am.
Have you had a chance to talk to Mr. Medina, or did you hear what he was saying?
No, I haven't had a chance to talk with him since I've been incarcerated, but I heard exactly what he said just then.
Okay.
And Your Honor, going forward, if this is not resolved today, and I anticipate it will be resolved today, it'll probably be Mr. Thomas Koch's case going forward, but like I said, I think it can resolve today.
Okay. Is the state comfortable if Mr. Davis chooses to resolve his VOP without it being in writing?
Yes, ma'am, as long as he's very familiar with the system, and I believe Mr. Medina's worked hard on his behalf, so we do not have any concerns about that.
Okay.
Your Honor, I would want to do a little bit of extra colloquy to make sure he understands the rights he's waiving since it's not in a written agreement, but I think it's super simple to him because he's done this in the past to understand it. May I state what the agreement would be?
Go right ahead.
So, Mr. Davis, in the 3 cases that you have before the court, there's 25 CF 524, 25 CF 522, and 23 CF 199. In exchange for the following agreement, you'd be admitting the violation. You were previously adjudicated guilty of a 3rd-degree felony in each of those cases. You would be admitting the violation. The probation, which is actually community control of 2 years, that would be reinstated and modified. There would be an additional 3 years probation added to the balance of your 2 years community control. You would have to complete the existing obligations. You would have $300 total VOP costs from $100 VOP fee times 3. You'd have $350 in public defender fees. Those monetary obligations would just be added to your probation. And that is the proposed agreement. If that is okay with you, if it is not okay with you, that is totally fine. Nobody's pressuring you. It's just an accommodation on the state's behalf to not keep you in jail. Instead of executing the 10-year suspended sentence, which would remain in effect, because that's one of your existing obligations. So you're still going to have a 10-year suspended sentence hanging over your head, but it wouldn't be executed. You'd be getting a chance to walk out of jail or, get out of jail in your wheelchair and take care of yourself. Is that what you want to do?
Can I say something first, please?
It would be better for you not to discuss your case. I am recommending that you not discuss your case, and I'm not there to counsel you. So I'm not recommending you start talking without your attorney talking for you, other than if you want to do this or not. So you've heard my recommendation.
Yes, I did. Yes, I take that offer.
Okay. So,
Ma'am, that it was the state's offer, and the only thing is I do want to point out and remind everyone that one of the original conditions was the GPS monitor, and he'll need that attached prior to being released.
Okay.
So that's one of your existing obligations. Like I said, all the existing obligations are continued, including the balance of your 2 years on CC, but you're adding a 3 years, it's being added 3 years probation. Do you understand?
Yes, 3 years probation, 2 years CC.
The balance of the 2 years CC, you did a little bit of it, I think.
Yes, I did. I did. Like, do that count for anything? I've been like,
That, whatever CC you did so far is still credited to you, but you have to
Okay.
complete the balance of the CC. I don't know how much you did.
Looks like.
yes, go ahead. I'm sorry, Judge.
Oh, so sorry, sir. I was just going to say the sentence date appears to be June 16th, and that was for 2 years community control. So, whatever the balance.
I'm sorry, Judge.
Whatever the balance
Maybe
is.
you did 5 or 6 months, I don't know, something like that.
I don't know, but.
Nobody's pressuring you. That is the offer. Is that what you want to do?
Yes, Your Honor. Yes, my lawyer. Yes.
Thank you, Your Honor.
All right, let me swear in Mr. Davis and ask some questions. So, Mr. Davis,
Yes, ma'am.
if you're able, could you please raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do, ma'am.
Thank you, sir. You can put your hand down. If you'll just state your name for us, please.
First name Preston, last name Davis.
Thank you, Mr. Davis. You're here in 23 CF 199, 25 CF 522, and 25 CF 524 on allegations that you violated your community control. I'm going to tell you what the allegations are. The first one is that you failed to remain confined to your approved residence. And it looks like Officer Doobie says you were away on January 19th, 2026 at 21:30 hours without prior approval, and that was evidenced by your electronic monitoring. Then the second allegation is that you went to Mary Esther Bingo, which is a violation of your one of your conditions of your probation, and that was on January 19th, 2026, allegedly, and that's evidenced by the electronic monitoring also. So those are the two allegations that you violated your probation. So do you need more time to talk to your lawyer about those allegations and any ways you might have to fight the case?
No, there's no need. I was wrong for doing that. I did it for an important reason to get my medication, and I know I was wrong, so I admit to it. I'm sorry to the courts, to the state, and thank everybody.
All right, thank you, sir. Let me make sure that you understand fully before I accept that admission. Do you understand you're giving up your right to have a hearing and make the state present evidence to prove one or both of those violations?
Yes, ma'am.
Do you understand you have the right to have that hearing, and that if you enter into this agreement and admit the violations, you're going to give up your right to have the hearing?
Yes, ma'am.
Okay. Is anybody forcing you or threatening you to admit the violations?
Not whatsoever, ma'am.
All right. Are you admitting the violations freely and voluntarily?
Yes, I am.
All right. Have you had any type of, I'm sure you're on medicine for your condition, but are you on any type of medicine that affects your ability to understand what's going on right now?
Not at the moment, ma'am, no.
Okay. Mr. Medina, do you wish to inquire further or put anything on the record?
I just want to expressly repeat, do you understand that this 10-year suspended sentence is still hanging over you?
Yes, I do.
Okay, thank you.
So let me make sure that I understand the terms of the agreement and that Mr. Davis understands the terms of the agreement. So what I understand, and I'm just restating to make sure we're all on the same page, that Mr. Davis would be reinstated and modified. He'd have to serve the remainder of his community control term, whatever that is. that was imposed on June 16th, 2025. Then once that's finished, he will have 3 years of probation after that. And all the cases are concurrent, meaning at the same time, and then there's still the 10-year suspended prison sentence that could be imposed if there's a future violation. And Mr. Davis would still have to complete all of his original terms and conditions, whatever those are, that were imposed back in June of 2025. And then there would be additional fees and costs on top of whatever was already assessed, $100 per case for a VOP fee, so a total of $300. Let me confirm with Madam Clerk, okay? And then cost of defense would be $100 per case for a total of $300, plus a $50 application fee in 23 CF 199. Well, first of all, Mr. Medina, is that accurate?
Yes, Your Honor.
Okay. Mr. Davis, is there anything I said that you didn't understand?
No, ma'am. I understood everything you said, ma'am.
Okay, and is what I just said, is that your understanding of the agreement that you're accepting?
Yes, it is, Judge.
Okay, is that what you want to do, sir?
Yes, ma'am.
Okay, I accept your admission on the violations. I find it was freely and voluntarily given, and then the resolution of your violation of probation cases will be just what I stated: reinstate and modify. Add 3 years of probation onto the term, so when you complete your community control, whatever was previously ordered, the 2 years, then you'll have 3 years of probation after that. You'll have to do all the original terms and conditions. You'll have to have your GPS installed prior to your release. So if they can do that today, and I don't know, but if they can do that today, I'm going to ask Officer Varese.
We will try, but if we can't, it'll be tomorrow morning, and then he needs to report immediately.
Okay,
If it's
Can it-
today, then today, before 5.
okay. So yes, sir?
Ma'am?
Yes.
But today, or I have to wait tomorrow, or when does that GPS have to be put on my ankle? I know before, but I get released, but it'll be today or later or what? I don't know.
Going to be tomorrow morning, but we will try to get it done this afternoon.
Officer Varese is here in the courtroom. I know you probably couldn't hear her very well. She said they're going to try to get there before 5 today, but she
Okay.
says that it's most likely going to be in the morning before they can get there. But they will try to get there today if at all possible. And then as soon as you get the GPS put on, if it is today, you'll have to report first thing in the morning. Officer Varese, if he gets it on tomorrow, what does he need to do?
If he gets it on today,
Go to the probation.
he will most likely not make it into our office until tomorrow morning, so then it will be 8 a.m. tomorrow. If it's tomorrow, and directly after he gets it put on. we will
Okay.
do it right away. I do need an address though.
Oh, Officer Varese needs an address of where he's going to go, or what?
Yes,
Okay.
because he's on community control, I just want to make sure that we have the same address.
Officer Varese is asking to confirm the address of where you'll be living.
Right now, you need it now? I mean, I know it by heart.
Okay, go ahead.
33 West Audrey Drive, Fort Walton Beach, Florida, 32548.
Thank you, sir. Thank you.
Your Honor,
Yes, let me
I'm
just tell Mr. Davis about the GPS. So, Mr. Davis, what Officer Varese said is they're going to try to see you today to put it on, but it looks like it's more likely going to be tomorrow. If they are able to put it on today, you need to be at probation first thing in the morning, like before 9 o'clock. If it's tomorrow, then after you get out of jail, go straight to probation right then and check in. Okay?
Yes, ma'am.
All
Yes,
right.
ma'am.
Anything else?
yes, Judge, I just wanted to say on the record, Mr. Davis, the state and the jail are doing everything they can to support the fact that you need to be focused on your health. So, but please realize while you're on community control, if you got to go to the doctor, I'm sure they're going to want you to go to the doctor, but you got to, whatever you're doing for your medical appointments and so forth, you got to get it all approved, okay? Because you're on CC.
Yes.
Thank you, Your Honor.
All right, so Mr. Davis, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I will appoint one for you, and good luck to you, sir. Thank you.
Thank you, and thank you, court.
Yes, sir. All right, that will conclude Mr. Davis, and I believe Mr. Carasso will be out shortly, and then we can handle his case.
Thank you, Your Honor.
Thank you. Mr. Carasso is present. Let me just get to his case in the docket.
Steve Medina with Nicholas Carasso Jr., Your Honor, 22 CF 360. Your Honor, I haven't been able to provide this information to Mr. Carasso, but I need to put on the record the state's offer that was tendered to me yesterday by the state so that he is aware of it. I would ask Mr. Carasso to not say anything, and then the public defender representative going forward is going to be Mr. Thomas Koch, who's in the courtroom. He doesn't know your case yet, but he's going to come see you and decide. You're going to decide what's in your best interest as far as your approach. But I wanted to put on the record the state's offer today is not something you're going to want to take, so just don't say anything. But it's basically they want to impose the 22-year DOC suspended sentence. You were given a reverse split of 20 years probation followed by 20 years DOC as a suspended sentence. And so they're now contending that you violated your probation and want to impose that suspended sentence. And that's all I can tell you today, Your Honor. I do believe that the last time he had his court appearance on February 18th, we entered a denial at that time. We now know where the state's position is on this. Not that it wasn't anticipated last time, but if we could have a continuance without a VOP evidentiary so that Mr. Koch can go visit with Mr. Carasso and decide on their approach, Your Honor.
All right.
And just for the record, I was filling in for other lawyers, so.
Understood.
Thank you.
So what I will do is continue Mr. Carasso's case, 22 CF 360, to April 21st at 9 o'clock. And Mr. Carasso may appear by Zoom if counsel wishes him to.
Thank you, Your Honor.
Okay. And just work that out with the jail, Mr. Koch, if you want him to appear by Zoom. Just coordinate it with them, okay?
Absolutely.
Okay, thank you.
Thank you, Your Honor.
Thank you, Mr. Carasso. And thank you to everyone at the jail.
Yes.
Have a good day.
Thank you. You too, thank you. Let me go ahead and take Mr. Nopes if he is ready and his inmates are ready. Oh, good, thank you.
So Judge, back to John Burkos, 23 CF 2379.
Yes, he is present.
Judge, I don't know exactly what the state's offer is today, but we'd like to know, and then we might be able to resolve it.
The offer is 1129, Okaloosa County Jail adjudication. Looks like this is his second VOP.
Judge, we're not going to accept that at this point if we could just get the next VOP date.
All right, so would we like to go ahead and schedule an evidentiary hearing? I do have dates.
Judge, it's up to the state if that's what they want to do.
That's fine with me, Your Honor. It looks like it's a failure to report absconding and a new law violation.
Okay, so here are some dates. Let me just double check them. I the morning of April 16th.
15th?
16th, it's a Thursday.
Let's see what I've got on the 16th. I've got to be here on that day with Judge Stone, so that should work.
All right. Does that work for the state?
Yes, ma'am.
Okay, so this will be an evidentiary hearing, VOP, on April 16th at 9 o'clock. That'll be our next court date, so I won't schedule the April 21st date because we'll address it on the 16th.
Absolutely.
So, all right. Anything else I need to cover today?
I don't believe so, Judge.
Okay, thank you.
Pamela Henson's up next.
All right, I have Miss Pamela Henson, 23, CF 818, and 25, CF 2466. And she is present, along with Mr. Nopes.
Judge,
We're here for a bond hearing, I believe,
that and
and also status on the other matter, the 2023 case.
yes, ma'am. So I did get an email yesterday from Margaret Borello, and she's the new, she's forensic mental health specialist that's been assigned.
Okay.
So she thinks that she can help provide the other services that had been previously outlined. I did also receive an order from the court that looks like it was signed yesterday or e-filed yesterday.
Yep.
That you had revoked her bond based upon the new arrest.
Yes.
And I guess, so it's right in line for, that we've already filed asking for the court to set a bond and possibly let her back out. And I think what the court's order had said is that you would consider scheduling another evaluation. I think is what it said.
Yes, let me find the statute.
Yes.
They need to be solved, their case is going to drop.
I understand.
So I guess, well, which case would you like to address first? Because I know there's a bond motion in 25 CF 2466, and then we've got the conditional release issue in 23 CF 818.
Yes, ma'am. So, let me just look here real quick. She also had an arrest for a misdemeanor, which she settled that. I don't know if the court's aware of that.
Yes, ma'am. Yeah, I was guilty of that charge. I did time served. And take full responsibility for that case.
Give me just a minute. So Judge, right now, the thing that's holding her, I believe, is your, I'm sorry? So Judge, I think it's the revocation on the controlled release is probably what's holding her up. I think she had a bond set on the new case.
So,
And Judge, I don't remember from memory who did the previous evaluation, the mental health
I have
profession.
it. I have it here. And
I'm out, okay. I understand, but I can't hear you and listen to her.
so I have the report. This is from Dr. McDonald back in July. I think it was filed in July of 2025. Yeah, that's the date of the report. And at that time, Dr. McDonald was recommending outpatient restoration, and the report states there was no indication that Ms. Henson currently met involuntary commitment criteria. I'm reading from paragraph 2 on the last page of the report, and it goes on to say, although her legal history does reflect a pattern of aggression/violence and dysregulated behavior, suggesting that she has at times presented as a risk to others and may do so in the future. That is paragraph 2 of Dr. McDonald's report. And so the court ordered outpatient restoration because that's what Dr. McDonald recommended at that time. And that was, I believe, in July or August. And it's been difficult to get that off the ground, and I still don't know, as I sit here right now, if any services have been provided.
Yes, sir. Yes, ma'am. I've been in treatment since 2023. I checked myself in
No, ma'am, that's not what I'm talking about. I'm talking about new services to restore you to competency. So I don't think anything has happened, and some of that is not through Ms. Henson's fault.
Right.
It's because of the, at the time, there was one particular forensic mental health professional, and then that person left, and then there was a new one coming, and the name you told me today, Mr. Nopes, is a different one than what I thought, so
Right.
I don't think there's been a provider that's been able to provide those services.
This Margaret,
Miss Maggie.
ma'am. Judge, the Margaret Varela, who I guess is in Crestview.
Okay.
She's the forensic mental health specialist. She indicated that she's on board to currently help completing, what she needs to do. However, she's finishing her required training to provide the services outlined, but she can't do that as of yet. But she's about to be qualified to do that. She just doesn't have that completed yet.
Miss Cindy.
Okay.
No, ma'am.
So I am going to be, well, let me read statute 916.17. This is about conditional release. So I had granted conditional release for outpatient treatment restoration. And I'm looking at paragraph 2 of that statute, and I'm going to read it.
Okay.
It says here, upon the filing of an affidavit or statement under oath by any person that the defendant has failed to comply with the conditions of release, comma, that the defendant's condition has deteriorated to the point that inpatient care is required, comma, or that the release conditions should be modified, the court shall hold a hearing within 7 days after receipt of the affidavit or statement under oath. Today, we're going to treat that as the hearing.
Okay.
So I don't have to set another one in
Thank you, ma'am.
7 days and come back. After the hearing, the court may modify the release conditions. The court may also order that the defendant be returned to the department if it is found after the appointment and report of experts that the person meets the criteria for involuntary commitment. So I need to reappoint Dr. McDonald for another evaluation because the situation has changed since July. Because I did review the new law offense, which is case number 25 CF 2466. That includes violent charges, allegations. Ma'am, there are just allegations.
Yes,
but-
ma'am, allegations, and
but-
I'll release the videos
Hold on just a
publicly.
minute, wait just a minute. Then there was also 26 MM 135, which has been resolved, but there's an adjudication of guilt in that case as well. So one of the conditions of release was not to have any more law violations. I'm also concerned that there's probable cause that the defendant has committed violent offenses.
No, ma'am.
There's
I didn't
probable
touch
cause,
anybody.
there's probable cause, and
Ma'am, I didn't
so,
touch anybody.
ma'am, just a minute, I'm talking. So there's probable cause that the defendant has committed additional violent offenses, which changes the situation possibly from what Dr. McDonald found about criteria, meeting criteria. And that's why I read that paragraph 2 from Dr. McDonald's report about Ms. Henson at that time in July didn't meet criteria, but Dr. McDonald noted that Ms. Henson has at times presented a risk to others and may do so in the future. So I need Dr. McDonald to reevaluate and determine if criteria is met for a more formal type of restoration. So I will be entering that order for the reevaluation.
Yes, ma'am.
And then, in fact, I'll enter it in both cases so that it'll count for both.
That will give you both.
I need bond, ma'am. I've got things going on out there, and I really need a bond.
So the next
Consider a bond.
issue, that would take care of case number 23, CF 818, except for setting a court date. So I will be reappointing Dr. McDonald.
I need a bond.
And the conditional release is revoked. That's the order I entered last night.
I desperately need a bond, ma'am. And I have been taking medicine, and I go monthly to Bridgeway, and I provided Cindy with all that information. I handed her my phone, and she saw my prescriptions, and I take them. I had a meltdown, I'm gonna tell you. That's why I pled guilty on the phone calls, because the week that I was here on the other 2 charges, I didn't have my meds, and I immediately, it was abruptly stopped, and that's what occurred. And I'm not guilty of the other 2 charges. When the state sees the video, I don't know if they've seen it yet, but I have a feeling this is gonna be dropped because it didn't, a drop of water didn't hit the deputy.
Okay, so let me.
They're saying a drop of water hit the deputy's feet, Miss Clark. And my dad's dying, and I desperately need a bond. I have court on my eviction on Thursday. I'm gonna lose all my property, everything that I've worked hard for.
So, Mr. Nopes, do you wish to be heard on?
Judge, she has indicated she needs a bond, and I've tried to tell her that you're going to tell us whatever your decision is about the bond. I don't think you're going to give her a bond because you've ordered the reevaluation, and then we'll hopefully get that
I will get
report.
the evaluation immediately and see the pre-trial, see Cindy. I only got to see Cindy one time, and I handed her my phone. She saw my prescriptions, and I take them. It was a drop of water. A man, Devius Hendricks, pushed through my door, and a drop of water hit the deputy's foot, he said, and that's why I'm here. He was berating me, saying I peed on his handcuffs, and I threw my glass of water at my feet. It was a styrofoam cup, and he was from here almost to that podium up here.
You're being recorded.
I know.
Everything
I
you
know.
say could be used against you in the case.
I know. The video cam's gonna speak for itself, ma'am.
Okay, let me see what the state has to say, okay?
Your Honor, regarding the conditional release, the state was going to move, if the court didn't, for a new evaluation. So the state is in agreement with the court's decision on this. In the new case, 25 CF 2466, the bond was revoked in that case?
Bond was revoked as a result of the misdemeanor violation.
Your Honor, Ms. Henson pled out to the misdemeanor, so it admits that there was a new law violation, and it's the state's position that that bond should remain revoked as well.
So,
Please, I need the bond. I will do whatever stipulations you say, but I desperately need a bond.
so bond in 25 CF 2466 was revoked when there was a first appearance in.
I have done
20
everything.
Ma'am, please don't interrupt.
Okay, I'm sorry, I
20
apologize.
That's okay.
My knees are about to buckle, I'm not
26
incompetent.
26 MM 135 was the misdemeanor case. That was the basis for revoking bond in 25 CF 2466. And now there's been an adjudication of guilt in the misdemeanor case, which.
I was sitting and I just
So-
pled out to it.
You're arguing to the court.
I'm not
Would you please,
arguing,
would you
no.
just be quiet and let her do her job?
Okay.
I'm denying the motion for bond because there was a new law offense committed while you were on pretrial release in
Ma'am,
25 CF 2466.
I'm gonna lose everything.
Good luck, ma'am. Let's set a next court date for you. How about April 21st? In both cases at 9 o'clock. And I will make sure that Dr. McDonald is appointed and she'll come and see you there at the jail and do the evaluation. With any luck, we'll have it back, but I'm a little worried we won't have it back by April 21st.
You gotta be kidding me.
April 21st?
Thank you, ma'am.
Thank you, Judge.
Mhm.
I'm releasing the videos publicly as soon as I get my hands on them.
So I have an order here, and I'm entering it on that case.
Frank?
Ms. Matthews, are you ready?
Yes, Your Honor.
All right, come on up.
Good morning, Judge Cheyenne Matthews on behalf of Mr. Paul Borderland in 4/6/2026 CF 68. We are here today on the defense's motion to modify Mr. Borderland's pretrial release conditions. Essentially, we're asking the court to modify his bond conditions so as to remove the GPS ankle monitor provision, with all other conditions remaining the same. We did have some delays this morning. Me and Ms. Gaynor were trying to get a hold of the victim in this case. We were able to, the alleged victim in this case has been reaching out to Mr. Borderland and his friends, trying to make contact. It's through Facebook Messenger, so there's not a working phone number. I spoke with Ms. Gaynor. She asked if Mr. Borderland's friend could reach out and see if she would provide a phone number this morning, let her know that we were with the prosecutor and that the prosecutor is trying to get a hold of her. She did block him after she read that message this morning. So Ms. Gaynor did make attempts with their investigator to contact the alleged victim through email and phone number, and they have not been able to get a hold of her. We are asking to move forward with the hearing today. I'll let the state speak on their position on that, but that's kind of where we're at.
Okay.
Your Honor, that is correct. I have previously tried to contact this victim from the inception of this case, and I have not been able to reach her. She has contacted my office once through my victim advocate, so there has been slight contact with her, but I myself, she won't answer my phone calls, and her voicemail box is not set up for me to be able to leave a voicemail. When I learned this morning that she's been speaking to the defendant's sponsor, I did, ask that sponsor to please let her know I'm trying to contact her, and I would call her again right at this moment. I did try that. She is not answering. I sent numerous emails to her, to the 2 email addresses that I've got for her, to no response. Being that this isn't a change of a contact order per se, changing it from no contact to no violent contact. This is just removing the GPS monitor. I'm not going to have an objection. I have crossed my T's and dotted my I's on trying to get her input on that. And so the state is not going to object to the GPS monitor being removed.
All right. So in light of that, I will grant the motion to modify pretrial release to remove the GPS.
Thank you, Judge.
All other terms and conditions will remain in effect, including the no contact. I do have a blank order, and Ms. Matthews, if you want to fill it out,
Yes, Your Honor.
I will sign it today, so that way it'll be in the record.
May I approach?
Sure. If you could just fill it out, and then like his name and case number and everything on there, and then I'll be happy to sign it, and then there's an order in the record that makes that modification.
Thank you, Your Honor.
Sure.
Can I just take a seat to fill this out real
Yes.
quick? Okay.
Yes. Thank you, sir. Good luck to you.
Thank you.
And may he go ahead and head on out of court, and I'll get the proposed order?
Yes, no, I don't know how you go about getting that removed. You would need to contact pretrial services, sir.
Okay.
And they're not going to have a record of it until they get the order that Ms. Matthews is about to fill out and I'm going to sign. And then the clerk's office they've got it in their minutes. So I don't know. Okay, pretrial services will get a copy. I just don't know how quickly that's going to happen since we're in court for the remainder of the day. But if you will let them know that you were in court today and that this happened, that way they can be looking for it.
Okay.
So, okay.
Thank you, Judge.
Yes.
Sure, thank you. Thank you. Do I have Kyle Hamilton present? This is case 23 CF 2372.
Good morning, Your Honor.
Good morning. Are you Mr. Kyle Hamilton?
Yes, ma'am.
All right. I'm Judge Clark, and you're here for your request for early termination of probation. And let me look the case up on my computer. I looked at it recently, but okay, it looks like you were placed on probation for 36 months. That was in August of 2024 with Judge Ketchel, and I don't see any violations. So what I'm going to do is ask what the state's position is, and also I'm going to confirm with probation that you've met all the requirements.
Yes, ma'am.
Okay, and let me see what the state has to say.
Your Honor, the state discussed this with Officer Burris. The state has no objection to Mr. Hamilton terminating early. It appears that he's doing well, and it looks like his prior history was pretty remote in time. There is a $31.20 court cost, including surcharge, left that Officer Varese notified the state about.
$31.20?
Yes, Your Honor.
And is that, let me check with Madam Clerk.
It must be on probation side because it's not included in the financials.
Okay, so as far as the clerk, their costs, everything's paid up, so let me see what the $31 is.
It is the drug testing fee.
Okay, so how does he take care of that?
$30 drug testing fee that has to be paid through correct pay.
Is he able to do that right now?
Yes, of course you can. You can do that online. There's a website.
Okay.
I got cash or card on me.
It has to be paid through probation, so,
I thought all my probationary fees were waived. I didn't know that there was one of the, I mean, I don't have any problems with the $31 by any means, but,
The drug testing fee cannot be waived.
okay.
so
No
do
problem.
you want to sit down for a minute and talk to Officer Varese and
Yes,
see
ma'am.
how to get
However I
that
got-
taken care of?
Yes, ma'am.
Once Officer Varese confirms that's taken care of, I'm filling out the order to terminate your probation. So let me know, and you'll come back up to the podium, and then we'll confirm, okay?
Yes, ma'am. Thank you, ma'am.
Sure, if you'll just go sit by Officer Varese and get that taken care of, okay? Is Heather Johnson present? Come on up, ma'am. This is case 23 CF 2801 and 24 CF 2241. All right, are you Heather Johnson?
Yes, ma'am.
All right, I'm Judge Clark, and let me get to your paperwork. You're here on allegations that you violated your probation, and the allegations are court costs and restitution, so let me pull that up. Okay, the first allegation is failing to pay court costs in case 23 CF 2801, and it says as of January 26th, 2026, you were in arrears in the amount of $1,015. Then the second allegation is court costs in 24 CF 2241. As of January 26th, this affidavit says you were in arrears in the amount of $811.38. And then the third allegation is failing to make restitution, and this affidavit says as of January 26, 2026, you were in arrears in the amount of $290.94. And you have the right to have a lawyer represent you. Would you like me to appoint one? Or
I
you-
have receipts that I've paid everything off.
Fantastic.
I came to the courthouse and paid I believe it was $1,800, which I have on the receipts, and then I also went on the correct pay to pay off my restitution. I was waiting for some money to come in to be able to do that, so I was able to do that.
Let me confirm with the
Sure.
clerk and with Officer Varese.
This is correct.
So she's paid everything. Let me confirm with Madam Clerk.
See the balance for 23 CF 2801. Zero balance for 24 CF 2241.
Fantastic. So we've confirmed, and let me just look for one other thing. So it looks like looks like your supervision ended a month ago.
Yes, ma'am.
Okay, so does the state, what's the state's position?
Your Honor, the state dismisses the violation of probation.
Thank you.
Thank you,
Thank you so
ma'am.
much.
You are considered successfully terminated from probation, and an order will be entered. The state has dismissed the violation. You've cured the issue, so good luck to you.
Thank you.
Thank you. All right. Do I have, oh, I don't see Mr. Medina. Thank you. Okay, I've received the order on Mr. Bordelon, 26 CF 68. And I'm going to sign it.
Thank you, Judge.
Thank you. All right. This is we will go ahead and start on our inmates. If there is anyone who is sitting here who has a case and I have not called you up to the podium, please come on up. If you have a case today and you haven't been called up. Yes, sir, if you could tell me your name.
Chad Carter.
Oh, Mr. Carter, yes.
Yes, ma'am.
Nice to see you.
Nice to see you.
So, here comes Mr. Medina right now.
Oh, yes, Your Honor.
All right, let me get
Chadwick Carter, Your Honor.
Let me get to Mr. Carter's case. That would be 23 CF 1270. And Mr. Carter's present.
Your Honor, I filed another notice of confidential information with court filing on March 12 and 23 CF 1270. I cited what I at that time thought were the two appropriate provisions, and I know Your Honor has since entered an order probably on the previous one, so I may not have done it exactly like Your Honor.
You did it just fine.
Okay, good.
Yes.
So as the court is aware, he's remaining under treatment and has provided what I understand is his up-to-date treatment records. Do you have anything beyond what you provided then?
This is from March the 11th and from January the 28th.
Okay, I think we already have the January 28th in the record, Judge.
Yes, I
But
think
may I
that-
show the,
March 11th is in the record too.
oh, okay.
Yes.
So that was basically an appointment. Did you go to, may I inquire of him?
Sure. Would you like me to swear him in?
Oh, yes, Judge.
Okay, if you'll just raise your right hand, other hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down if you will state your name one more time for us.
Chad Carter.
Thank you, Mr. Carter. Go ahead, Mr. Medina.
Your Honor, I apologize. I'm the one who instructed to be filed this, the Care Connect records, but I don't see the New Hope Clinic March 11 appointment record that he's showing me.
Oh.
It may be that,
I have something from March 11th.
well, you do have March 11,
But
that's
it's
right.
Care Connect.
I think what it is they have different terminology on, yeah, okay, so New Hope Clinic is part of the Care Connect health system. So
This
that's-
is what I
We
have.
have it. We
Okay.
have it. And he's got his med list as well, Your Honor, which is probably redundant of what's already in the treatment list in the paperwork. Sorry
Okay.
for my confusion.
All right, so What is the state's position?
Your Honor, the state, I believe we've got the order was from June of 2025 that had him on conditional release for a period not to exceed 1 year. I see that he has, according to the March 11th report, he's got another appointment in May. The state's position would be to keep him on for one more status hearing.
Let me look.
Mr. Koch is going to take over your case going forward. He was ready to handle it today, so he's right there.
Okay, so when is the next appointment that you have? It's probably in these records.
In May.
Okay. Oh, I see it, May 7th. May 7th, 2026. Okay, what I'm going to do is set a final visit or a hearing to see that visit. And let's set it for May 19th. So you will be able to get those records from your May 7th visit and then provide them to your lawyer, who's going to be Mr. Koch, I believe, very soon. And he's sitting right over there. So this would be May 19th at 9 o'clock for another compliance hearing.
And Your Honor, if Mr. Carter chooses to appear by Zoom, is that acceptable so he doesn't have to drive all the way down from Georgia?
That's fine, I would say.
Yes, I'll put Zoom on here.
Okay, thank you. So, Mr. Carter, if you prefer to do a by video connection through Zoom, you can. You don't have to come in person, but it's always great to come in person. But
Thank you.
be careful driving, be careful on the highway.
Technology-wise.
Okay.
So whatever you prefer, just let Mr. Koch know if you're going to appear by Zoom so he can let me know. And you need to get your records, just like you did this time. When you go to your May visit, get your records as soon as you can after that visit and get them to your attorney so that they can file them before the hearing, just like they did this time.
Yes.
Okay? And then that would, assuming everything is still in compliance, that, well, we'll see what the state has to say, but thank you for taking this seriously and for complying.
Yes, ma'am. Thank you for working with me.
Yes,
Okay,
sir.
There's your paperwork, okay? May 19, 9 a.m., okay?
Okay.
Thank you.
If you need the Zoom information, reach out to Mr. Koch, and his office will get it for you if you decide to go that way, okay?
Thank you, Your Honor.
Thank you. We're just continuing. Compliance here, or I guess I'm setting another one. Yes, ma'am.
My name is Ariel Bowles.
Yes, yes, I saw you on the docket, but at the moment I saw your name, I didn't see Mr. Medina in the room, so I thought I would wait till he came back, and let me just get that.
Okay, Your Honor, may I advise the court?
Yes, oh, let me get the clerk number on here. It's 22 CF 3175. Ariel Bowles, she is present.
Your Honor, Ms. Bowles has official receipts from the clerk's office showing that she made significant progress this last cycle, apparently, paying. Can you tell do you want her to be under oath, Judge? She just wants to explain what she's paid, but she has a little bit to go.
Okay, just raise your right hand, other hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
So would you tell the court what your name is?
My name is Ariel Bowles.
And how much progress did you make on your court costs, and how much is remaining to be done?
So I owed $865, and I have paid $430 on my first time and $230 on my second, leaving $205 left.
Wow, that is a lot of progress.
I definitely tried.
Good job.
Let me verify with Madam Clerk. That is correct. Yes, they've verified it's correct. So what about, I think community service might have been another thing.
That was all done too.
Oh, good. So what would you like to do, Mr. Medina?
Your Honor, do you think if the court gives you a couple more months, you can get the other 200 paid off? Your Honor, could we put a May or something like that court date?
How long do you need to pay off the balance?
I'd give it 60 days if that.
Okay, so what's the state's position?
Your Honor, May would be fine with the state. I did speak with probation this morning. She did have some cost of supervision that they noted that also need to be owed, but the state has no objection to waiving any cost of supervision, and probation's okay with that.
The court will waive whatever balance of cost of supervision. I'm writing that down. So I'm going to set your next court date for May 19th at 9 o'clock. And
Your Honor, I think she's going to need to come to court no matter what, so that even if the decision's made that she's paid everything, I think the court will need to see her to decide if that means probation can be terminated or
yeah, I think
so forth.
I think so. I think probation, the expiration date was last month, so we're going to set you for May 19th at 9 o'clock. I'll see you then. Stay in touch with Mr. Medina. All right.
Thank you. All right, good job. Thank you, ma'am. Thank you, Your Honor.
Thank you. And yes, Mr. Hamilton.
Yes, ma'am.
All
I'm taking
right.
care of that with the probation.
Officer Varese, are we all good with Mr. Hamilton, case 23 CF 2372?
Yes, Your Honor, the DS made the payment.
All right. So does the state have any objection? I think I asked earlier.
No objection, Your Honor.
I'm granting your motion, sir. And thank you for taking probation so seriously.
Yes, ma'am.
You've done everything that we've asked you to do, and you've been a model probationer, and that is very much appreciated.
Yes, ma'am.
So I am filling out the order right now to terminate your probation immediately.
Yes, ma'am.
Okay?
Thank you so much.
Good luck to you.
You too, ma'am. Thank you.
Thank you.
Thank you.
Your Honor, can I mention one thing that I...
Yes.
I had hoped that Angel Benitez was going to be transported today. I don't know what happened. My file said he was supposed to transport today, but he's not here. I was hoping we could, I think Your Honor has court in 2 days. Could Mr. Benitez slip to the March 19th docket at 9 a.m.?
Let me just take a look. Okay, I've finished the order on Mr. Hamilton, 23 CF 2372. And I'm handing that to Madam Clerk. His probation.
Sorry, Judge.
Oh, no.
I didn't realize the court, Your Honor, was doing something.
Oh, no problem. I was just trying to enter the orders on the motions. So let me find Mr. I believe that is case 21 CF 2886, Mr. Angel Benitez, and yeah, I don't see him on the list.
On my file, I wrote March 17th, but it may be I made a mistake.
No, he's on the docket. He's number 22 on the docket. So I'm not sure.
Somehow he slipped through the cracks, Your Honor, and we didn't catch it until about 10 minutes ago.
Okay, so we can put him on the, let me look and see what we have on the Thursday morning.
I think it might be a special set, I can't remember.
We have several things on Thursday morning, including, I know you had filed an emergency motion.
Yes, that's going to be not needing, I had contacted Your Honor's assistant. We're not going to need a full hour.
Okay.
It's either going to be a plea or send to county court situation, so we're not going to need to address that on the merits.
Well, in that case, that frees up some time.
Yes, Your
So
Honor.
we can put him on the morning of March 19th, and let me just make a note.
Thank you.
Sure. March 19th at 9 o'clock, and I need to send Amanda a message, let her know, because she prepares the docket for that morning.
Thank you, Your Honor. I just didn't want to forget.
Sure. This is case 21, CF 2886. Now, is this going to be, you said it's going to either be a plea or transferred? No,
Your
you're
Honor,
talking about
that
the other
was
one.
That was, I was referring to Cordova Martinez.
Okay.
He was set for the emergency hearing. He's not going to have an emergency evidentiary hearing.
Okay.
I was referring to Jose Omar Cordova Martinez.
Gotcha. So, Mr. Benitez, will that be a VOP evidentiary or?
No, Your Honor,
Okay.
it's going to be it's either going to be a plea or probably plea or set for VOP evidentiary. I anticipate it's going to be a plea. The state had made an offer
Okay.
basically it made him an offer, and then his other alternative was a plea to the bench. I think he's probably going to take the state's offer.
Okay.
But it won't be a lengthy proceeding, Your Honor.
So if you could just, if you're able, check the jail transport list
Yes,
and make sure
ma'am.
that he's on it.
We'll do, Your Honor.
Okay. So I have just sent a message to Amanda to add him to the docket for Thursday morning, March 19th at 9 o'clock.
Thank you.
Sure.
I apologize, I didn't
Oh.
catch that.
I didn't see it either, but I don't usually start looking at the docket until 9 or 10 o'clock at night. So even if I had noticed it, I wouldn't have, I mean, it would have been too late. So I believe, all right, I see a lot of people sitting in the gallery, and if you have a case and I haven't called you up, please come on up. Otherwise, I'll assume you don't have a case today and you're here as either a family member or a
Your Honor,
victim or.
I know there's a family member of Mr. Solomon
Okay.
who's probably next on the no attorney list. I don't know if he's already appeared.
No, I'm just going to start going down the docket at this point.
I know his mother's here.
Do I have Stephanie Berryhill present? Okay, I'll come back to that one. Okay, Mr. Dane Solomon, 21 CF 499. Good morning, I'm Judge Clark. Can you tell me your name, sir?
Dane Charles Solomon, Your Honor.
Thank you. And my paperwork shows that you don't have an attorney representing you. Would you like me to appoint one?
Would that be today, Your Honor?
Yes.
Absolutely, Your Honor.
I'm appointing the Office of the Public Defender. And there's Mr. Koch. He will be representing you.
Your Honor, may I ask if Mr. Solomon has an offer currently?
Go right ahead.
If I may?
Mr. Solomon scores 42 months in the Department of Corrections. That is the state's offer at this time.
Do you need some white noise or?
Just briefly, Judge.
Oh.
Judge?
Yes.
I just first want to enter denial here in the offer and being appointed. I'd request that this case be put on that April 21st without subpoenas at 9 a.m. if that's the next court date.
Yes.
And we were just appointed Mr. Solomon. Everything's recorded. The judge is here, the state attorney's here. I recommend not making any statements, especially I know, I'm not going to interrupt you, but please do not I advise you not make any statements.
Thank you, but I would like to speak, Your Honor.
Okay, before you do, I need to tell you some things, okay?
Yes, ma'am.
First of all, you're being recorded. Anything you say could be used against you.
Yes, ma'am.
I've got a table full of prosecutors
Absolutely,
right
ma'am.
there.
Yes, ma'am.
Second, there's nothing you're going to say right now that's going to resolve the situation.
Just like to speak.
I just want you to know that,
I'd just
okay?
like to speak, Your Honor.
Go right ahead then.
Thank you, Your Honor.
Mhm.
Dear Your Honor, God bless. I have an overwhelming joy for our Lord Jesus. This experience has been self-revealing. I have come through these jailhouse bars calm and collect this time. I am ashamed of how I've acted on previous occasions. I guess this is growing up. Over the past year and a half, I aced Spanish 2 and environmental science. I am now currently enrolled in mathematical thinking and anatomy and physiology at Northwest Florida State. I maintained a part-time job at McDonald's and had both children all summer long while on probation. The mother of my children was in Oregon working all summer. I collected disability while getting Medicaid and dental through work. I was in charge of all doctor's visits, food, shelter, hygiene. We skateboarded, played music, took turns reading at night, swam, exercised, prayed. We attended church. We also wrote nightly journals, manifesting positive thoughts for the next day, and writing everything we are grateful for. The mother of my children was very happy. We were passionately engaged in rebuilding our relationship. October, I was detained for drugs. After multiple drug tests and blood work, all results were clean. I spent 10 days Baker active. After they released me, I turned in a full 20-page document to the probation office of Fort Walton Beach and a copy of my restraining order that the mother of my children applied on me while I was Baker acted to Officer Morales immediately. When asked what to put for police contact, she said I got the reports, so I wrote NA. I guess she got sick or had family problems because I received 2 new probation officers, preparing to see a third one, Officer Mayweather, for March, for my final 19 days of probation. I resumed life after being Baker acted. The mother of my children dropped the restraining order. We're on better terms than ever, still friends. I coach my son's basketball team at Jet Drive Rec Center Tuesdays and Thursdays. He has Brazilian Jiu-Jitsu on Monday and archery on Wednesdays. I'm doing well in school and I'm getting ready to add a part-time job. Then I get arrested hours after dropping my son off at his mom's. My son is pretty upset about the whole thing. I'm using this time to become closer to Jesus. So I pray, Lord God, our Heavenly Father, please bless the family of our courts, bless them with health and happiness, inspire all to reunite me with my family and community in accordance to God's plan. Amen.
Thank you, sir.
Thank you.
I will see you on April 21st at 9, and I'm sure Mr. Koch will be out to see you, okay?
Thank you, Your Honor.
Thank you.
Gerard's wrong, but next.
All right, is this Mr. Jeriel Jones? 24 CF 15. And yes, sir, I am Judge Clark, and I noticed that you don't have a lawyer on this case. Would you like me to appoint one?
Yes, ma'am.
I'm appointing the Office of the Public Defender. There's a plane going overhead. I can't hear you right now, so let's wait till that thing goes over. Just can't hear. So. I'm sorry, sir. If you were saying something, I couldn't hear you because of the airplane noise.
I'm sorry. Yes, I would like to be appointed a lawyer. I thought I would have already by this time, but I guess I'm not. By the way, I was wondering, with today's, I know I was supposed to be a VOP arraignment hearing, would I still be able to post a bail? Because, I mean, I had one, but they said with the VOP that I wasn't able to until I had came for the hearing. I was wondering if there was a possibility that I would be able to post a affordable bail, because I also was in the process. I got my family members to talk to the director of JADA program, and I do need some help because I made some rash decisions over the past few months, and I really would like to try and seek that help.
So let me let me go over the affidavit. We are here on a violation of probation.
Yes, ma'am.
Affidavit, and there's an affidavit that was filed on March 2nd, 2026, and I've appointed Mr. Koch for you, and he is there. He's an attorney. And I'm also noting there's a new law case, which is 26 CF 404. And I know we're not here on that today, but I noticed that the PD's office was not appointed at first appearance. And I see Ms. Gaynor standing.
I don't believe they were, Your Honor, and I did just want to inform the court, I did file on that new law case this morning.
Oh, okay.
And I can read those charges out if you'd like.
So arraignment on that case is not until April 16th. What I was going to do is make sure that I appointed counsel on the new case because I didn't see where an attorney had been appointed for you on your new case either. So would you like me to go ahead and appoint Mr. Koch on that case too?
I guess.
Oh.
Ma'am. Yes, ma'am.
Okay. I'm appointing the Office of the Public Defender on case 26 CF 404. So now you have an attorney on both of your cases.
Yeah.
And Mr. Koch, I don't want to put you on the spot. We're set for arraignment in the new case on April 16th. Do you want to leave that set? Or Ms. Gaynor said she filed this morning if you want to do arraignment today. It's up to you. Yes. Oh, sure.
I'd like to move forward, if we do that arraignment on that new law, Your Honor.
Okay.
I first want to just inform the court, current guidelines with the new law is 61.95 months. That's the current offer.
Okay.
Of course, I just heard the offer, I just want to share it with the court. And then with that new law, 26 CF 404, we can waive formal reading, enter not guilty, Your Honor. Due to the nature of the charges of this new law, may I request that the VOP and the new law be placed on your next pretrial docket?
Yes, and so let me see which date you'd prefer, because the new law right now is set for June 8th. I think we would probably need to move that anyway, but I have an April pretrial date. Do you want the April date, or do you want to leave it set for June?
If we could take that April date, just so I can speak with my new client at the jail, and just to keep them both together.
Okay, what I will do is set both cases, that's 24 CF 15 and 26 CF 404 will be set for pretrial conference on April 15th at 9 o'clock. So the VOP case, which we're here on today, will just track along with the new law, so.
Excellent. And I'll enter denial, Your Honor, in that VOP case.
Okay, yes, the allegations in the VOP are all new law offenses that were alleged to have been committed on February 21st, 2026. There are, looks like 5 allegations of various alleged new law offenses. So, regarding a bond on the VOP, that's set at no bond, it would remain on no bond.
Yes, Judge.
On a VOP.
Yes, Your Honor.
Okay. So that would be April 15th at 9 on both cases. All right? Thank you. Thank you.
Up next from Mr. Medina is Erica Cook.
Your Honor, it's okay, I've got the reasons. Oh, I got it, yeah. No, you're good. Your Honor, we're reading my email clients are coming out, and we've got agreements on 2 of these.
Okay. So we'll have cancels Mr. Burns' arraignment.
Your Honor, Steve Medina with Erica S. Cook.
All right, let me
And
get to,
Ms.
there we go. This is 23 CF 2487.
And Your Honor, I am making one small clarification and agreement that the state's already signed. I'm just going to add that when she gets out from her jail sentence, that she can have 12 months before the monetary obligations go to collections.
There's no objection from the state.
Okay.
May I write that on there, Your Honor?
Sure, and I'm also pointing out there's Okaloosa County Sheriff's Office requesting reimbursement for transportation.
How much was that, Your Honor?
$226.05.
And I know Your Honor had told me about that last time she appeared, so I don't think she's surprised by that, so. 12 months to pay. And Your Honor, we've been over the agreement except for me adding this language, 12 months to pay monetary obligations upon release.
All right.
And I've explained to her what that means. She's signing the agreement that we've been over, Your Honor.
Okay.
And I've been over the, I couldn't physically show her, but I am showing her now. We discussed this, the score sheet, so we don't have any questions on that. She's not scoring DOC, Your Honor.
Okay.
And I am making I think, Your Honor, I need to show this to probation so they can make a photograph.
Sure.
I apologize. I didn't
No problem.
make, copies.
No problem.
Your Honor, we will not be required to present a score sheet because it's not more than 44 points. Does the court nonetheless want to have the score sheet?
We still need one, sir.
I need a score sheet.
Yeah, I'm sorry,
Yeah,
Judge.
that's
I'm
okay.
just,
No problem.
I've got it.
Okay.
Because it's a revoke and terminate, you need to see it anyway.
Okay.
I'm sorry, I
Nope.
need another cup of coffee to.
No problem.
May I approach?
Yes. Thank you very much.
I think Your Honor can read my
Yes,
handwriting.
Yes, I can.
So.
All right, ma'am, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you. You can put your hand down. And if you'll state your name, please.
Erica Cook.
Thank you, Ms. Cook. You're here in 23 CF 2487, and you're here on allegations that you violated your probation. I'm looking at an affidavit that was filed. Let's see. It was filed on January 13th, 2026, but I believe it was...
I think it might have been superseded, Your Honor. The one, I went over both of them with her, but the one that seems to be before the court, I could be wrong, but was from September 22nd. And it's an affidavit violation of probation that only has one violation of condition C, which was an address change.
Yes, in fact, I think it was just refiled in January, which is, but it looks like the same affidavit.
We've discussed both. I think that she may have had a defense to, I didn't do my own research, but I think she represents that basically the failure to report within 72 hours of release would have been a possibility because of being picked up for an Alabama hold. And the rest were in that prior BOP seemed to be, absconding would be covered by the same excuse, basically. So I'm not sure if that's still operative, but she would be denying some of that stuff, but admitting the current question of the September 2025 not doing an address change, basically, or not being at the address she was supposed to be.
Okay, so there's an affidavit from October of 2024, and it has numerous allegations. 7 allegations. And then there was a first appearance in May of 2025, at which time there was a bond. And then there was a failure to appear in October, that's October 21st, 2025. So another warrant was issued. And then
Yes, and Judge.
Rearrested in December.
And Your Honor, on the FTA, I should have written down, I didn't realize that was floating around, but basically she was, I do have proof she was incarcerated in Houston County, Alabama at the time of that. Was it October 21st appearance, Judge?
Yes.
Oh, let me make sure on that proof, Your Honor.
Okay.
I apologize. May I have just a moment?
Sure.
I do, as an officer of the court, in good faith, need to acknowledge error on my part. The Houston County confinement doesn't show admission until October 30th. So as to the FTA, I would ask the state to agree that the state would not be proceeding on the FTA.
No, we will not be proceeding on the FTA. This will resolve Ms. Cook's case.
Okay. I see a note about waiving prior credit. I think that was mentioned at the last.
Yes, and Your Honor, that we did, that was our point of negotiation that was central to today's agreement. The state has agreed to relent on that issue in exchange for a plea on the term of the jail is going to be 11 months, 29 days. But she will be getting credit for all her time served. That's no longer a waiver.
Just wanted to verify. All right, so, ma'am, I believe I swore you in a second ago.
Yes, ma'am.
Okay, thank you. So, there were allegations back in, I believe, October of 2024. There were 7 of them, and then there was one from September of 2025. Have you had a chance to talk to your lawyer about all of the allegations that you violated your probation?
Yes, ma'am.
All right. Have you discussed the agreement with your lawyer?
I have.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the back?
It is.
Do you understand the rights that you give up when you admit to violating your probation?
I do.
Do you understand you have the right to have a hearing and make the state prove the violations?
Yes, ma'am.
Do you understand you're giving up that right?
Yes, ma'am.
Is anybody forcing you or threatening you to make you admit the violations?
No, ma'am.
Has anybody promised you anything to make you admit?
No.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
All right. Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
All right, I have a score sheet, and it shows 42 total sentence points. Any objections or corrections?
No, Your Honor.
All right. And was there a previous adjudication? Let me just check.
Your Honor, there was previously a withhold. She advises she has a felony conviction, one or more, obviously just one up in Alabama. So she's already a convicted felon, so this is going to be an adjudication of guilt, so she'll have another one for the Florida case.
Okay. So. All right, ma'am, are you freely and voluntarily admitting the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made. In accordance with your agreement, the court finds that you're guilty of violating your probation as alleged in the affidavits And the court also adjudicates you guilty of the original offense. And in accordance with the agreement, your probation is revoked and terminated, and you're sentenced to 11 months and 29 days in the Okaloosa County Jail with credit for all time served. And the following additional fees and costs are going to be imposed. This is on top of anything previously assessed. $100 VOP cost of prosecution fee, $150 cost of defense. That includes the $50 application fee, and $226.05 to Okaloosa County Sheriff's Office for cost of transportation. And then after you're released, you'll have 12 months to pay all of your outstanding fees and costs before they go to collections. Once they go to collections, that'll probably suspend your driver's license. So if you need more time, go see the clerk before that year is up, and they'll work with you on a payment plan. And you have 30 days to appeal the order of the court, and if you can't afford a lawyer, I'll appoint one for you. Good luck, ma'am. Thank you.
Right this way, Mr. Judge, next up is Megan Dotson.
All right. All right, and Ms.
Probably doing Dotson, Your Honor?
Yes, Ms. Megan Dotson, 25 CF 1338. She is present.
Your Honor, Ms. Dotson is before the court with a violation of probation that she's going to be admitting to pursuant to an agreement.
Okay.
She's signing the agreement that we've previously been over. The underlying charge was a lesser included offense misdemeanor, so we don't have a score sheet.
Okay.
It's 317, yes, ma'am. Thank you. And it was JCS probation, so I don't think probation needs to make a copy here, Your Honor.
Okay.
May I approach, Your Honor?
Yes.
It's signed.
Thank you.
Mr. Ferris, I'm going to put 3/17/26 by your date.
Oh, yes, thank you, sorry.
Thank you very much. All right, there we go. All right, Ms. Dotson, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you. You can put your hand down. And if you'll just tell me your name.
Megan Elena Dotson.
Thank you, Ms. Dotson. You're here in case 25 CF 1338 on allegations that you violated your probation. And the affidavit includes 5 different allegations. Wait a minute, I think 6. No, 5. They're not numbered, so it was hard to tell.
That's what she's looking at.
Have you had a chance to talk to your lawyer about those allegations that you violated your probation?
Yes, ma'am.
All right.
Your Honor, may I?
Yes.
I just wanted to explain to the court, she has a medical issue that doesn't prevent her from understanding what she's doing, so I'm not implying that, but it is a bit complicated, so I'm going to state what I think her understanding is that there was some things that she may have wanted to have a defense on. She's admitting the VOP, but she's probably not wanting to admit every single thing. But there are certainly some things that she's going to admit to, such as the alcohol consumption issue, and she understands just based on that alone that the court could violate her. So she's not contesting that there was a willful and substantial violation, Your Honor.
Okay.
But for instance, a failure to report, she did tell me she might have had an issue with that.
Yes.
So it is complicated. I just didn't want her knowing that she couldn't try to explain it.
Understood. So have you discussed the agreement with your lawyer?
Yes, ma'am.
Yes, I have discussed it.
Okay, did you read the agreement?
Yes, ma'am.
And
It clearly states, I understand.
is this your signature on the back?
Yes, ma'am.
Okay, do you understand the rights that you give up when you admit a violation of probation?
Yes.
Do you understand you have the right to have a hearing and make the state prove the allegations?
I did not know that.
Okay, you do have a right to have a hearing, like a trial, but there won't be a jury, and make the state prove the allegations?
Yes, ma'am.
Do you want to give up that right?
No.
I think you want to waiving the right to a hearing.
I want to waive a right to the hearing.
Okay, so you do not want a hearing, you want to take this
I just want
deal?
Yes, ma'am.
Okay, so by taking the deal and admitting the violation, then you're not going to have the hearing. Do you understand?
I understand.
Okay. Is anybody forcing you or threatening you to make you admit any of the violations?
No, ma'am.
Has anybody promised you anything to make you admit the violations?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Okay. Have you had any alcohol or any substances that affect your ability to understand what's happening right now?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what's going on right now?
No, ma'am.
Are you admitting to, well, Mr. Medina, which ones, just the alcohol or?
My understanding is that she would for sure be admitting the failure to abstain from alcohol. I think that she was not wanting to admit the failure to report because she expressed to me that she thought there was a misunderstanding, that she actually did or did try to report. I'm not sure exactly what the details are. And that she also indicates that she may have some information on the mental health evaluation, that she wasn't violating that. And then the others were costs of supervision and court costs that are just accelerated normally, and I don't think she's contesting that she hadn't paid those things.
Okay, so are you, ma'am, are you admitting the allegation about testing positive for alcohol
Yes, ma'am.
and not abstaining from consumption of alcohol?
Yes, ma'am.
Okay, I accept your admission. I find it was freely and voluntarily entered. In accordance with your agreement, the court does find that you're guilty of violating your probation on that allegation about the alcohol consumption, and your probation is revoked and terminated. You are sentenced to 180 days in the Okaloosa County Jail with credit for time served. In addition to the previously imposed fees and costs, there is an additional $100 VOP cost of prosecution fee and $150 cost of defense. That includes the application fee. And you'll have 6 months after you get out to pay all of your unpaid fees and costs before they go to collections. Once they go to collections, your driver's license will likely be suspended. So you have 30 days to appeal the order of the court, and if you cannot afford a lawyer, I'll appoint one for you. Good luck, ma'am. Thank you.
Kimberly Lovelace is up next.
Steve Medina with Ms. Lovelace.
Yes.
She has 3 cases before the court, 23 CF 2152, 24 CF 1074, and 25 CF 381.
Yes, just one second. Let me get to that. Okay.
Your Honor, when she was before the court last time, we indicated we were going to get her evaluated for Keaton. Our PD investigator has diligently worked on that issue. There apparently is a major backlog right now for Keaton evaluations, so she went the extra mile, and frankly, I had hoped it was going to get done yesterday. The jail and our investigator have worked very hard, and Keaton sent us a list, and she's number 1 on a list of a dozen or so people to be evaluated, but apparently it didn't get done yesterday. I'm asking that we do a April next court date. If we hear something, it's always possible we'll hear something tomorrow. I'll do everything I can, consistent with the court's and state's directions to advance it once we know she's in Keaton. The state is adamant that she do a Keaton deal. There's not going to be any kind of straight incarceration option that we know of that the state would find acceptable. The state was also not willing to reinstate for community control. Obviously, when somebody gets treatment, it's important that they desire treatment. I've talked to her about that. I think she does desire treatment. She is a military veteran, so I've expressed to her she's free to talk to the VA about an inpatient, long-term VA option if one becomes available. But right now, the one that we know is the recommendation is Keaton. So hopefully we get that indication in the next day or two, Judge.
Okay, so I will set Ms. Lovelace's cases, all three of them, for April 21st at 9. And Mr. Medina, if you need to bring the case in earlier, if you hear back from Keaton and y'all work something out, then we will do our best to find time to do that.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Right this way. Ashley Rico is up next.
All right, and Ms. Rico's cases are 2019 CF 893 and 2019 CF 2258, and she is present. All right.
Yes, Your Honor. Thomas Koch, covering for Mr. Gates. Just reviewing his notes, may I ask if there's a current offer?
There is currently no offer. The state will get one over as soon as possible. What does that mean?
As of right now, the two cases you have, there's currently not an offer, Your Honor. We'll be entering denial on both those cases. Request that this be set on the, one second. Request this be set on the April 21st at 9 a.m. without subpoenas. Of course, if we do get an offer and my client is willing to accept that, if we may advance that on the docket so we can enter that.
Okay, so April 21st at 9 o'clock on both cases.
I have a question.
Yes, ma'am. Or you want me to turn on the, okay.
Please. Thank you, Judge. I answered those questions, and we request it be kept still on that 4/21 date.
Okay, April 21st at 9 o'clock. Thank you, ma'am.
Thank you, Judge.
All right, whoever is next. Yep, whenever you're ready. Okay. And let me get to Mr. Dawson's case. Just one second. I got an email about Mr. Dawson's case. We're here in 25 CF 767, 25 CF 768, and 25 CF 769. And we're here for status of Phoenix House, and an email came through to my judicial assistant on Friday, and it says, I'm just going to read it verbatim. It is from probation. Ms. Perez can help me with pronunciation. Is it Sandy Lavati? Lavati. Okay. And it says, there was a hiccup with the jail not wanting to release him on the 18th/19th of February. Officer Browner spoke with Phoenix House admin, who states that it is taking a bit longer to get a bed space, but states they are going to be picking him up by the end of this month. I wanted to let you know, I'm not sure the officer in court will have this information if asked, because we have several new officers. We have been monitoring his pickup continuously, and that there was a misdemeanor case that he was being held on, which had held up things. So I'm paraphrasing the rest of it without having to read it verbatim. But if you would like to see it, by all means.
That's fine, Judge.
Okay.
Thank you.
This was from probation, giving us an update on what's going on with Phoenix House. And there's Officer Perez.
Since then, we have another update.
Oh.
Phoenix House, because of DOC budgeting and external delays, they are not picking up anybody until the month of April.
Oh, my goodness. Okay.
Because we have another vendor that's also waiting on transport ever since August of last year.
Oh, goodness. Okay.
And they do have 15 other people waiting also in Okaloosa County Jail right now for transfer.
Wow. Okay. Mr. Koch, I know you're brand new to Mr. Dawson's case, and what I've been doing is just setting statuses whenever somebody pleads to Phoenix House or other programs, just to make sure that they get there.
Yes.
Because sometimes, you know, there are problems, and that way we can stay on top of it and see what's going on. So, what would you like me to do?
This is a new case because you pled out, condition of probation is Phoenix House, and we're waiting, as probation stated, an April pickup. I guess we get here's what I like to do. Of course, get a date in April. I'm also just gonna see if I can get him evaluated for other placement. I know it's not part of the terms, but maybe.
At this point, Keaton or
There's some
whatever.
other resources also at the office, Chrome program, I know,
Yeah.
inpatient. But I may just put my feelers out, and if he gets transported to Phoenix, great. If not, hopefully I can have another option on the table. Maybe we can modify that fee.
Yes, I will say that I'm looking, now Mr. Dawson pled in August, and in October, there was a problem, well, I have a note from October, because I set the first status in October, that there was a new case coming, but it was from 2024, but the warrant wasn't coming until, the warrant was issued in November of 2025, even though the allegations were from 2024. So it wasn't like he committed a new offense in the meantime. It was just, a delay between the alleged offense and then the warrant. So then that warrant was issued, and that held him up, from my understanding, because that case had to be resolved.
Okay.
So that was one of the reasons, and then, if I remember correctly, it might have been at our last court date, there might have been a lockdown because of flu. Flu at Phoenix House locked them down, and they weren't accepting new people for a while, and now we're here with this. So, Mr. Dawson, if there was anything I could do to get you to Phoenix House yesterday, I would have done it. So Mr. Koch is going to be your new attorney to monitor the case and see what can be done, and he's going to look at other programs, other alternatives besides Phoenix House for you. Okay?
I'll look.
Set Mr. Dawson for another status on April 21st at 9. And Mr. Koch, if you need to bring Mr. Dawson's cases in sooner, if something turns up that a different program that's acceptable to him in the state, then I'll do everything I can to get him in sooner to make that happen.
Yes, Judge, thank you.
Okay, thank you. Thank you, Mr. Dawson.
Troy Dowda is up next.
That's gonna be mine.
Dowda?
Oh, are you ready to talk? You got it.
Mr. Troy Dowda in 24 CF 2153, Your Honor.
Yes, let me just get to that. Okay, got it.
Judge, I first want to indicate there should be another case number. I don't believe it's on the docket, but if I may provide that case number.
Yes, I would most appreciate that.
24 CF 2281.
Thank you. All right, let me pull that one up. So we've got 24 CF 2153 and 24 CF 2281, and let me just get that one in here. I see that. Yes, that one, I'm not sure why that one wasn't also set. Okay. Thank you. Okay, I have both cases pulled up.
Okay, excellent, Judge.
Yes.
Your Honor, speaking with the state attorney this morning, there's currently, well, when this case was originally pled out, there's a 4-year suspended sentence on this case.
Mhm.
So that is the current offer. But my client is accepted into the faith-based inpatient program in Bonifay.
Okay.
They're willing to accept them bed ready. Speaking with the state attorney, she's going to run through her proper channels, and hopefully they can accept our counteroffer in this case. The allegation is an alleged positive UA. So I'm asking if we can keep or set this for the 4/21 without subpoenas, but if we get the counteroffer, I of course can advance you on the docket so we can edit that.
I'll do everything I can to move the case in sooner if you need me to.
Excellent.
Okay.
And we will be entering a denial, Your Honor, in both those case numbers.
Okay. And we will set Mr. Dowda, both of his cases, for April 21st at 9. Okay?
Excellent.
Thank you.
All right, Spencer.
Yep.
Rashawn Hampton is up next.
All right, and
This is Mr. Sean Hampton, Your Honor, in 23 CF 906.
all right, let me just get to, okay. I have that in front of me, and the defendant is present.
Yes, Your Honor. And Thomas Koch covered for Mr. Gates. Reviewing his notes. I believe Mr. Gates emailed about a potential counteroffer for credit for time served. If I may just ask for the current offer.
The current offer is still 6 months.
It's still 6 months. Thank you for giving that offer. Your Honor, may I just have a brief moment to...
Sure. Thank you.
And just speaking with my client, he was reviewing what Mr. Gates has been working on. The current offer is 6 months. At this time, Your Honor, we'll keep with the denial. Can we get this set for 4/21 without subpoenas?
Yes. April 21st at 9 o'clock. All right, thank you.
Thank you, Judge.
Keith Jackson is up next.
All right, that's case number 2013 CF 24, 2013 CF 25, and 2013 CF 39. And Mr. Jackson is present.
Judge, Thomas Koch covered for Mr. Gates. I'm his trial partner this morning. Your Honor, just reviewing his notes, can I ask for the current offer?
The current offer is 94.2 months DOC, revoke and terminate probation.
May I just have a brief moment, Your Honor?
Sure. Yes.
Judge, if we may pass up Mr. Jackson so I can get a plea form ready.
Okay.
So he's interested in accepting that 94.2 months with credit for time served, revoke and terminate offer today.
Yeah, I believe there's more credit than that, is there not?
Just looking at Mr. Gates' notes, it looks like he has roughly 10 years of DOC credit.
That's what I see as well. So, was that the state's understanding also?
Your Honor, the state is asking it without the credit.
Ah,
Okay, that changes, okay.
I'm glad I
Absolutely.
think that was something I needed to clarify.
There was a 20-year probation period after his release, so the state's not going to agree or stipulate to credit for a violation.
What are my violations again?
Sorry?
What is my violation again?
Let me read that to you. So, I'm looking at an affidavit filed on December 23rd, 2025.
Yes, ma'am.
And it is, there are 5 allegations, but let me read them out to you. Number 1, and I'm just giving you information. I
Yes,
don't want
ma'am.
you to respond because I don't want you to say something that might hurt your case. You're
Yes,
being
ma'am.
recorded and there's a table full of prosecutors sitting right there, okay? So I'm just
Understood.
telling you the information, okay?
Yes, ma'am.
All right, so number 1, it's alleged that you failed to report on, let's see, you were instructed to report on November the 3rd, and 2025, and that as of December 23rd, you had not reported. And then number 2 is that you absconded from supervision, that on or about November 3rd, 2025, you had concealed or absented yourself from supervision. Your whereabouts were unknown. Then number 3 is you failed to comply with instructions that on December 22nd, 2025, you were instructed to report that morning, and you failed to carry out that instruction by failing to report that morning. Then number 4 is failing to pay court costs, and the total amount of all three cases was $3,429.24. That was the balance among all three cases as of December 23rd. Then number 5 is that you failed to complete 24 hours of community service. And that it says, as of November 3rd, 2025, you had absconded without completing your community service. So that's what the affidavit says that was filed on December 23rd, 2025 in all three of the cases.
Okay, may I ask a question?
You want?
You ask me first.
Sure.
I think I answered my client's question. Your Honor, we'll be entering denial here in the offer if we can have this set for 4/21 without subpoenas.
Yes. All three cases will be set on April 21st at 9 o'clock.
Thank you.
Jamie on Sharp, is up next.
Okay, Mr. Javion Sharp, and the case numbers are 24 CF 1562, 24 CF 1563, 24 CF 1564, and 24 CF 1685. And Mr. Sharp is present, and we're here on a couple of different matters. First of all, Mr. Sharp was placed in the custody of DCF for competency restoration, and then they've returned Mr. Sharp to the court with a report. The report was filed on February 19th, 2026, and then, so we'll discuss that. And then also, Mr. Gates filed a motion to dismiss on March 4th, 2026. So we're here on both of those matters.
Yes, Your Honor, that's exactly what my notes indicate from Mr. Gates. He filed the motion, and I guess he's waiting to hear back on the state's position.
Okay.
On that motion to dismiss.
Your Honor, the state is opposed to the motion. The state does have 2 years from the date he was deemed incompetent to proceed and the order was entered for those charges to be dismissed. Has to be within a reasonable time. The state is moving for civil commitment at this time and for the court to enter an order for the Agency of Persons with Disabilities to have a further evaluation for inpatient treatment.
Okay. All right, response?
Yes, Your Honor. If, just reading Mr. Gates' notes, could he still have a hearing date to be heard on that motion to dismiss fully?
Yes.
I don't believe he said it yet, Your Honor. I think he's just waiting on.
That's right. I think today may have been a date to set the,
I think he wanted to hear the state's position, Your Honor.
oh, okay. So when would you like to set that? Do you want to set that on April 21st?
Is that acceptable for the state?
That is acceptable for the state.
Then that'd be perfect, Judge.
Okay. So April 21st at 9 o'clock will be the motion to dismiss. And then let me see about the order or the report from the facility. Okay, they are recommending the path that the state has just outlined.
Yes,
Your Honor, I know we're not here on the motion today, but there is just two cases that the state would like to provide to the defense and to the court, just to read
Okay.
ahead of time,
Thank you.
which pretty much highlights, if I may approach your Honor,
Yes.
just highlights that the court cannot dismiss the case
Thank you.
before the 2-year mark.
I've been handed State versus Rush, 425 Southern 3rd, 1146. That's a first DCA case from December 10th, 2025. And Mosher, Mosher versus State, 876 Southern 2nd, 1230. That's a first DCA case from June 10th, 2004. So, I just skimmed over that pretty quickly. I'm looking at the order adjudging Mr. Sharp to be incompetent. That was entered on February 26, 2025. And I believe that's, well, the oral pronouncement, don't know if that would govern or the written order, but the oral pronouncement was February 12th. The written order was entered February 26th. Either way, it's been about 13 months since the order was entered or the finding of incompetency was made. So we will continue the motion to dismiss to April 21st at 9 o'clock. And then is there anything that the court needs to do regarding the report that was filed on February 19th, 2026? That's from the facility. North Florida Evaluation and Treatment Center. So do I need to make a finding today, or do you, is that also deferred?
If we could wait till 421, Your Honor, I don't want to encroach on Mr. Gates' arguments or.
Your Honor, since the motion is continued, I believe today we'll just pass it along and we'll address all of that at the next court date. So that Mr. Gates is present, is able to make his argument.
Okay, then I will continue everything on Mr. Sharp's cases to April 21st at 9. Okay?
Thank you, Judge.
Thank you. And then if the state, I know you're going to file that proceeding with APD?
Yes, Your Honor.
Okay, thank you. All right, thank you. All right, so I think Mr. Medina might be. Okay, great. While we are waiting,
I see that at the top.
Yeah.
But when you look at the actual substance of it, where it lists current community control supervision history, it only lists the 22 CF 3028. I'm sorry, I didn't look up.
I do see that.
I didn't look up 23 CF 2758 to see what was the original sentence in that case. It may, I don't want to speculate.
Well, I have 23, are you referring to 232758?
Yes.
I have that one pulled up in front of me.
I'm sorry, Judge, I didn't
No,
do
that's
that.
okay. So I have an order of probation, and look, I can put it up here on the board.
I think we can easily add it, I just didn't see.
Okay, so there's an order that was entered on February 15th, 2024 in both case numbers. And there are the two charges. Each case is one count of possession of a controlled substance, and then
It's concurrent, it should have been both.
3 years of probation on each, concurrent. And this was entered, it was entered non-proton to December 21st, 2023, so that would go through December of 2026.
Could I have it back, Your Honor?
Sure.
We'll add that other DOT, I appreciate Your Honor
Sure.
looking it up. I
Oh, yeah.
apologize, I didn't do it.
No problem.
I just knew it was
Yeah.
it looked like a error of some kind we needed to correct.
And then, let's see, oh, that modification was old, so. And then there's a plea and sentence from 2024. Let me see what else I can find.
So, Your Honor, I'm going to put an asterisk at where we list the current cases, and an asterisk at the bottom, I'm going to list the 23 CF 2758 felony VOP. And then that will be covered by the agreement.
Okay, so there was a modification in 2024, and it just says placed on drug offender probation for the balance of supervision. So it didn't extend the term or anything, it just changed the probation to drug offender probation. That occurred on October 17th, 2024, and the order was entered November 4th, 2024, so that just changed the nature of probation.
You understand that? We've listed that one too.
Based on a previous violation. So then, I know the affidavit itself was filed in both cases, and let me show you that.
Yes, Judge, I showed that to him.
And it had both case numbers on it, and it listed the two allegations
Right.
that we're here on today.
And it's just obviously it was a scrivener's error at some point to not list both cases as continuing a current supervision, but we understand it is applicable to both, and it's in his best interest to include them both, so I have I've changed it accordingly and showed it to the state. May I approach, Your Honor?
Yes.
Y'all, you want to get another picture? Are you good?
No, we're good.
Thank you.
Okay. Thank you so much.
Your Honor.
So this agreement is going to resolve the new law case of 26 CF 365, which is currently scheduled for arraignment on Thursday, March 19th. So we can take him off the docket for March 19th. That way you don't have to come back for that. It's going to be resolved today.
Yes, Your Honor.
All right, thank you. And Mr. Medina, if you could check the transport list when it comes out on Wednesday and make sure that Mr. Cox isn't still on it.
Yes, Your Honor.
Okay, so that he doesn't get brought back to court and sit here all day with us.
Thank you, Your Honor.
On a case that's resolved.
Yes, Your Honor.
Yes. Okay.
I'm making a note. We will do that, Your Honor.
Wonderful, thank you.
And may I ask the clerk something? For a public nuisance, felony public nuisance, I put it as $515 court costs.
That's right.
Okay.
I think it would be a 100 VOP fee on each case and
That's correct. That goes-
350
Right, so it's gonna be
PD.
100 times 2, and your PD fees are $350 instead of $250.
Okay.
Do you understand?
I understand.
I'm writing that on here.
Thank you, Your Honor.
Sure.
Terminating, so you won't be on probation.
Okay. Mr. Cox, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. If you'll just tell me your name, please.
Jeremy Ryan Cox.
Thank you. So you're here in 26 CF 365, and in that case, you are charged with one count of keeping a public nuisance, which is a third-degree felony with a maximum penalty of up to 5 years in prison, and one count of possession of drug paraphernalia, which is a first-degree misdemeanor with a maximum penalty of up to 1 year in jail. Have you had a chance to talk to your lawyer about those two charges and any possible defenses?
Yes, Your Honor.
All right. And then in case numbers 22 CF 3028 and 23 CF 2758, it's alleged that you violated your probation in both of those cases. And I had the affidavit up on the screen a second ago. It was the two allegations which are the charges in your new case, your 26 CF 365. Those are the two allegations that you violated. Do you understand the rights that you give up when you enter a plea in your new case? Meaning one of them would be you're giving up your right to go to trial?
Yes, Your Honor.
All right. Do you also understand that by admitting to the violation of probation in your two violation of probation cases, you're giving up your right to have a hearing and make the state prove that you violated?
Yes, Your Honor.
You're also giving up other constitutional rights. I can go over those with you if you'd like me to. Would you like me to go over those?
No, thank you, Your Honor.
Okay, I think they're spelled out on the agreement on the top of the second page.
Yeah.
Your Honor, they are spelled out as to the new law case, and I had advised him he'd be waiving his right to a VOP evidentiary hearing. Just for the record, that would have a lower burden of proof, and it would not be a jury trial.
Yes.
Did you read and sign the agreement?
Yes, Your Honor.
Is that your signature on the back page?
Yes, Your Honor.
All right. And did you discuss the agreement with your attorney?
Yes, Your Honor.
Are you entering the plea in 26 CF 365 freely and voluntarily today?
Yes, Your Honor.
Has anybody forced you or threatened you to either enter the plea in the 2026 case or admit the violations in your VOP cases?
No, Your
Has
Honor.
anybody promised you anything to get you to do any of those things?
No, Your Honor.
Are you satisfied with the services of your lawyer?
Yes, Your Honor.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, Your Honor.
Okay. I have a score sheet, and it's a combined score sheet that has the VOPs on it as well, and it shows 31.7 total sentence points. Any objections?
No, Your Honor.
All right. And Mr. Cox, did you look at your score sheet?
Yes, Your Honor.
Did you see anything wrong with it?
No, Your Honor.
Okay. Is there any exculpatory DNA in the new case?
Not to our knowledge.
And Mr. Cox, do you understand that you are entering a plea in your brand-new case without the opportunity for your lawyer to review discovery?
Yes, Your Honor.
Is there a stipulation regarding the factual basis in the new case?
Yes, Your Honor. I did have certain information that I discussed with him, but as Your Honor is pointing out, we don't have all the evidence, but he believes it's in his best interest to take the deal.
Okay.
Yes. Your
All
Honor.
right. And Mr. Cox, if you're not a U.S. citizen, do you understand that this plea and admission could subject you to deportation?
Yes, Your Honor. I am a citizen, though.
Thank you. So in case 26 CF 365, how do you plead to counts 1 and 2?
No contest.
I accept your plea. I find it was freely and voluntarily entered. In 22 CF 3028 and 23 CF 2758, are you admitting the 2 allegations that you violated your probation?
Yes, Your Honor.
I accept your admission. I find it was freely and voluntarily made. In accordance with your agreement, there will be an adjudication of guilt on counts 1 and 2 in 26 CF 365. And the court does find that you're guilty of violating your probation in your 2 violation of probation cases. The sentence will be the same in all 3 cases, and they will all be concurrent. Probation is going to be revoked and terminated in the 2 VOP cases. And you were sentenced to 11 months and 29 days in the county jail with credit for time served on all counts. And let me go over the costs and fees. So in 26 CF 365, there is a court cost of $515. In,
Your Honor,
yes,
23 was just a VOP, it's just going to have a $100 VOP fee.
yes,
This 515, I may have written it incorrectly, but that's in 26 CF 365.
Yes.
I may have made a mistake.
no, that's 26 CF 365, the court costs are $515. And then in each of the VOP cases, it's a $100 VOP cost of prosecution fee. That's in addition to any previously imposed costs. Then these are the cost of defense. It's $100 per case, so that's a total of $300 plus a $50 application fee. And let me ask Madam Clerk where to apply. Where would you like?
The notice case number 26 CF 365.
Okay, the $50 application fee will be applied to 26 CF 365. And let me make a note of that. You will have a year or 12 months to pay all of your costs and fees after you get out, before they go to collections. Once they go to collections, that'll probably suspend your driver's license. If you need more time, go see the clerk before that year runs out, and they'll work with you on a payment plan.
Okay. Thank you, Your Honor.
Thank you, sir. You have 30 days to appeal the order of the court, and if you cannot afford a lawyer, I will appoint one for you. And just in case I wasn't clear, all cases and counts are concurrent, and all will have credit for time served.
Okay. Thank
Mr.
you.
Medina, did I miss anything?
No, Your Honor, thank you.
Okay. Good luck, sir. Thank you.
Thank you, Your Honor.
I'm sorry, not sure.
Mr. Cox,
Sorry, sir.
Andre Blackman's next.
Your Honor, may I just have some white noise for you?
Sure.
With Dondre J. Blackman, 15 CF 2266. I don't know if the court is aware, and I apologize, I didn't discuss this with Ms. Bossett before I filed it yesterday, but I was getting ready for court for my cases today and realized that it would be right for me to file a motion in limine for his case. And that would be a motion in limine that would apply when and if we don't work the case out and it goes to a VOP evidentiary hearing. I didn't want to just sit on it. It was something I needed to bring up. I'm not trying to be disrespectful to the state or anything. I did undertake some efforts to communicate, including in his last court appearance, that we would need the Facebook evidence on a Facebook-related VOP allegation. So I have filed that. I'm not trying to argue it today. I'm simply saying that we need to probably continue the case. I don't know, I can't remember what that's set for, if she did set it. I think-
April 21st. It's already set
Oh,
for
it is
hearing.
set, yeah,
Yes,
it is
it's
on
set
my
for
file.
hearing.
So we just need to continue him to April 21st. It's possible
Okay.
things will be resolved, but right now I can say that it seems to be a very important motion, because the evidence is either going to come in or not, and that seems to be, I think, the sole basis for the VOP is the alleged Facebook activity.
All right.
And it's a significant DOC offer from the state, just for the record. And I do appreciate Ms. Boss's feedback on the offer of the state is 76.5 months DOC with credit for all time served. So over the math is hard for me, but that's quite a lot in prison. Okay, so.
Okay. So, any objection from the state to set everything for April 21st?
No, ma'am, and we're going to do our best to resolve that before we get to April 21st to save everybody a hearing and hopefully give them the information they need.
Okay. So motion in limine is already scheduled for April 21st. So we will just continue the case till then to have that motion hearing if needed and go from there.
Thank you, Your Honor.
Thank you.
Come on up. Christopher Bobin.
All right, and Mr. Blackman's case that we just finished is 2015 CF 2266. And now in front of the court is Mr. Christopher Bobbin.
Your Honor,
who-
can I get some white noise?
Yes, let me read out the case numbers. 23 CF 657, that's the case we're scheduled for today, but there are 5 new law cases, 4 of which are scheduled for arraignment in 2 days, and I'll read those out in a minute, but, all right. Okay, go ahead.
I'm sorry, Your Honor, Steve Medina with Mr. Christopher R. Bobbin, 23 CF 657. What had happened was I had sent a list of cases that I was handling today to the state, and for whatever reason, I didn't have his files they were in my jail box, and before I could meet with him at the jail, here he is. But my understanding, Your Honor, is that well, does the state have a global offer at this time? Because I think I did realize I had omitted it from my list. Does the state have a global offer?
I know for my cases, the VOP 26 CF 347, 26 CF 348, and 26 CF 349, it's a 12-1 DOC offer.
So would that deal with the, because he has several 26 CF related, looks like they're felony petty theft charges. Is that going to deal with all his current cases?
All of those, I don't know what the child neglect charge is.
Oh, okay.
There is a child neglect.
Oh, I did see that, yeah.
Yes, sir, and ma'am, we are trying to seek some behavioral changes with that case and the safety of the children, so we would be looking for an adjudication and then 3 years probation to follow any DOC time with a no alcohol and parenting provision and comply with any case plan.
Let me read out the new law case numbers so that the record is clear. These are the ones I found. 26 CF 345, 26 CF 346, 26 CF 347, 26 CF 348. Now, those 4 are set for arraignment on March 19th. I'm hoping we might be able to do arraignment today so that Mr. Bobbin doesn't have to be brought back in 2 days and sit here all day.
Yes,
And-
Your Honor,
yeah.
he can waive arraignment and enter a not guilty plea on those cases.
And they have been all filed on, ma'am.
I checked that, so today is arraignment on those 4 cases I just read out, so that will take him off the docket for Thursday. And then there's another new law case that's not set for arraignment until April 16th. That one is 26 CF 484, and I think that one's brand new, so I don't think any information has been filed on that one yet.
And does the state know if any other cases are anticipated? Or do we have our handle on, probably,
I'm unaware.
Your Honor?
Yes.
So I guess he'll be coming back on April 16, the way it would stand now.
Yes, that would be for arraignment in 26 CF 484.
Rather than him foregoing his right to prepared counsel, because I don't know anything about these new law cases, I'm going to come and meet with him and decide what's in his best interest, and if he can just keep everything, or at least the plea day and the 26 CF 484, we can come back on April 16. We may be able to work out something global by then if we have more information.
About that next court date, so all of the 4 new law cases that we just did arraignment on, those are set for pretrial on April 15th. So rather than have him, I hate to talk about you like you're not here, sir, rather than you come on April 15th and come back the next day on April 16th for an arraignment, we could hopefully take care of maybe the arraignment on the new law case, the remaining new law case on the 15th.
Okay, so we wouldn't waive arraignment today, we would just do all the arraignments?
Well, no, I thought we were, you
Yeah,
did.
we did, we can.
Yeah.
So we're, April 15th is fine for the one remaining case, Your Honor?
We could do the arraignment on that day?
Yes, Judge.
Okay, instead of the 16th, which is the very next day. And then
Of course, Your Honor.
he'd have to be brought
Yes.
2 days and sit at the courthouse, which probably isn't a lot of fun to sit here. So that'll save you 1 trip. So
Okay, so the April 15th is pretrial conference?
Correct.
Okay, now I understand. So
April 15th is pretrial on 26 CF 345, 346, 347, and 348. It's already set. So then the very next day, April 16th, is arraignment in 26 CF 484. That's a brand-new case. I don't think the state has had a chance to even look at it, much less file their information, so we can't arraign that today. But rather than Mr. Bobbin come on April 15th for pretrial and stay with us all day here in the courthouse, and then turn right around the next day and have to get on the bus and come back for arraignment in another case.
Perfect.
I'm suggesting he do arraignment in 26 CF 484 in conjunction with his pretrial conference on those other 2026 cases, so it's 1 trip to the courthouse.
Sounds good, Your Honor.
Yeah.
And just for the record, if I didn't say it, he will deny the VOP in 23 CF 657, and I'll be out as soon as possible to meet with him about all his cases.
Okay, so when do we set, do you want me to just set the VOP for the April 15th date too, so it can track along with everything else?
Yes, Your Honor, please.
Okay, so 23 CF 657 is going to be set for April 15th at 9 o'clock, which is the same date pretrial conference is on 4 of the new law cases. And then, so every case for Mr. Bobbin that we know of will be heard on April 15th. That's your next court date for everything, and we'll take care of whatever we need to on that.
Okay.
Okay.
Thank you, Your Honor.
Thank you, sir.
Thank you.
All right.
May I have a moment with the state?
Sure, sure. And this is Mr. Hamilton Boykin, 24 CF 356. He's present. Yes.
We've reached an agreement. It's going to be a 10-month jail deal. I will need a moment to write it up. I hate to inconvenience the court and staff and so
You're fine.
It'll just take a minute. He can even sit up here if we need, if he's, I don't know if he's the last one. But.
Okay.
He's gonna wait in the queue.
I'll be willing to wait.
Okay.
Just go on back and we'll write it up. You, Thomas, can you write it up?
Brian Quinn, next.
All right.
Boykin, pretty simple. It's going to be 10 months for Okaloosa County Jail. I got it. You got it? Yeah, I got it.
All right, next we have Mr. Brian Corum, 25 CF 1491 and 25 CF 1878. And Mr. Corum is here on a status of Phoenix House, having pled on January 13th, 2026. And then you got held up because they were on a lockdown for flu. And then, so we're back. And then today, earlier, I heard that Phoenix House isn't taking anybody until April. Is that right, Officer Varese? Okay. So, Mr. Medina is present, and
Well, the one workaround, because I know he was very frustrated last time, and I think, I mean, the camera's rolling, so I'm not going to say anything about his personal situation, but I know it really stresses him out, the situation, the pressure he's under. His mother's usually here.
She's sick right now.
Right, so I think what I would like to do, Your Honor, is kind of like when Mr. Koch had a good idea with somebody else. It seems like Phoenix House has got so many pressures with the backlog, and even if when they start to flow, it's going to be a real slow process. So I'm very concerned about that. I know the Public Defender's Office is trying to keep tabs on these things. What I would like to ask is, can we put them on for April? I'm going to look to see if they're, may I have one moment?
yeah.
The state just simply allow them to do time served or something like that as
How much?
straight jail. And I don't think the state's had an opportunity to consider that option because his frustration is evident, but can the state give him a straight jail offer in lieu of in light of the Phoenix House unavailability? The other thing I was going to suggest to him is that we can look at a faith-based option instead of, and I'm not pushing faith-based solutions, but basically there are many nonprofits that probably have room, and maybe we could give him someplace else to go instead of Phoenix House if it's a good fit. But he's telling me he'd like to do straight jail because he's been in 7 months.
Yeah, the state's, it's not, I haven't looked at this to give you an offer of straight jail right now.
So, Your Honor, even if you wanted to ask to revoke his plea, it would be not in his best interest to do, given that we don't have any kind of an agreement from the state. Okay, so that's the status. I would ask to put him on April 21st if that's the next court date.
All right. So,
And if the state could then look at, would a straight jail be something the state would consider as a more or less a superseding plea agreement?
Yeah, I can get you something this afternoon.
Okay, thank you.
okay. So April 21st at 9 o'clock. And if you need to bring the case in sooner, then I'll do everything I can to make that happen. So, all right. Thank you, Mr. Corum.
Thank you.
All right, I think we have Mr.
Yeah, this is Mr. Your Honor, this is Clifford L. Dove before the court, 23 CF 1255. I don't know if the state had a chance to look at a point sheet issue that I raised.
Yes, so, I mean, the reason for the 18 is because there was a prior technical violation.
The only violation that he was aware of, and the only thing I saw listed was one prior violation that was a technical, from what he understands over, it's listed as technical violation, the date of disposition, September 17, 2024. Is that the only DOP?
So there's the new felony violation, and then there's the affidavit, the report is dated June 19, 2024. That may be the same one.
That's the same one, so that's the second one, so that would be 12 points, not 18.
There's a new law violation.
If there's a new law violation on a misdemeanor, that's different than if it were on a felony. I think the new law is only on a misdemeanor. Is that correct?
Yeah, petty theft.
It was a petty theft. I don't know if it was charged as a felony. Was it charged as a felony in
No.
Escambia?
No, it's just misdemeanor.
So respectfully, I think it should be 12 points instead of, if it's just a, I didn't check to see Escambia, but if it's just a misdemeanor, it wouldn't trigger a 12 points for the new law.
Okay, if that's the case, then let me rerun the score sheet. If we can push them back.
Your Honor, it's, basically, it's in his best interest is it gets checked. Could we move him, bring him back on the 19th, and by then the state will have a chance to check it? It should be easily conformable to whatever his, if the 6 points comes up, then he's not scoring prison, but just barely not scoring prison, and it would be understood he'd be agreeable to an 1129 deal.
Are
So-
you meaning check on the Escambia case?
No, Your Honor.
Oh.
The state can check on that if it wants to, but I think, I'm not sure what all the state wants to check on, but it won't take more than a day or two, I don't think.
I mean, it's possible that it could be, there's one more plea, or there's one more inmate back there.
I don't know.
What are you checking on?
We need to rerun the score sheet.
I think I was the last one.
Just a plea deal for Boykin.
I think we need to, Your Honor, make sure that Escambia was just a misdemeanor.
I'm looking at it.
And then the state needs to rerun the score sheet, and it's probably gonna be 12 points and 43 point whatever points instead of 49 point whatever.
I have the Escambia case right here, if you want me to put it on the screen.
That'd be great. It'd be much better to just go ahead and do it if people aren't gonna get mad at me for messing
Okay.
up their lunch.
So this is the court worksheet in 25 MM 5841
Right.
in Escambia County. It was
I
Judge
see
Ritchie.
Judge Ritchie up there.
So,
That looks like it.
restitution to Walmart, adjudicated guilty. Of course, it doesn't show the charge on here, but. I mean, it's misdemeanor cost and it's, it's a misdemeanor case number.
I think we can get it resolved now, Your Honor.
I can see the charge somewhere else and it's, let me get the information. Hold up. I'll show you the information.
Perfect. And then we'll change it to 1129 instead of, sure, thank you.
Here's the information. I'm about to put it on the screen.
Your Honor, I'm going to white out
Okay.
the 16.35 months DOC and put 11 months, 29 days Okaloosa County Jail.
There's the information. It was filed on January 4th, 2026 in Escambia case 25 MM 5841, and it was petty theft, and it was an M2.
Well, honest, you do not have any whiteout, so I'm gonna.
I have some. I have it.
It's like we all have it except you.
I'm all out.
Here you go.
I've been doing a lot of whiting out. Thank you, Your Honor.
Sure. Do you still need this up on the board?
No, Your Honor.
Okay.
We've got it
Thank
now.
you.
Thank you.
Sure.
Thank you.
Yeah.
Okay. Your Honor, I'm going to put 11 months, 29 days jail, rather than 11.29 months, because I don't want to create ambiguity. So,
Is there going to be an adjudication?
yes,
Okay.
11 months, 29 days, OCJ. And I'm going to show them where I did that. 11 months, 29 days, OCJ. Okay, you see that? That's good, right?
Yeah.
Okay.
Better than it was.
Your Honor, may I approach with your whiteout in the
Yes.
revised agreement?
Absolutely.
And I have a revised score sheet that I'm showing him that changes it from 18 VOP points to 12, takes the total sentence points down to 43.8. I'm going to strike through the 49.8, Mr. Ferris. I'm just going to strike through the 49.8 there just to, yeah. I just don't like to make changes without the state approving. And then he will no longer be scoring prison, Your Honor.
All right.
May I approach, Judge?
Yes.
And he's going to go ahead and sign it now.
Okay.
What's the date?
I got it.
No, okay.
3/17.
I think it's supposed to be for today, but it wasn't enough, and I don't know what happened.
Oh, shoot. I started writing Mr. Ferris's bar number down there for him, but it was my bar number. And I think he needs that. Oh, no, shoot. Yeah, Judge, this is one, the form has the signatures in a different place, and Mr. Ferris needed to sign it again. You need to sign it again in a different place. It's very confusing. I apologize. Can you sign again? This is the PD. This one has the PD down there at the bottom for some reason. So you need to sign there. That's a different location than the other form. We try to confuse you. Your Honor, I don't have the privilege of being a member of multiple bars like Mr. Ferris, so he has to look into his Rolodex for the right bar number. Okay, we're good? Thank you. May I approach, Judge?
Yes. Thank you very much.
Your Honor, it's not perfectly written. Here's the court's, may I approach?
Oh, yes.
So it is
Thank
11
you.
months, 29 days OCJ. I hope the court can read that.
Yes, I can. All right,
Ms.
Mr.
Ma'am,
Dove,
did you get that change?
you'll please raise your right
Is
hand.
that credit with time served too?
Yeah, you
Yes,
get
it
your
says so
credit.
on here.
Yeah.
Yeah, would you like to look at it again?
No, you're fine. I'll just.
Okay, and I'll announce it also. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Clifford Lee Dove.
Thank you, Mr. Dove. You're here in 23 CF 1255 on allegations that you violated your probation. And I'm looking at an affidavit that was filed on December 18th, 2025, and it has two allegations in it. The first one was failing to report on December 10th, 2025, and the second one was the new offense in Escambia County that we just looked at, the petty theft. Those are the allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations?
Yes, ma'am. That's how we came to that conclusion.
Have you discussed this agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the back?
Yes, ma'am.
Do you understand the rights that you give up when you admit to a violation of probation?
Yes, ma'am.
Do you understand you have the right to have a hearing and make the state prove the allegations, and you're giving up that right?
Yes, ma'am.
Is anyone forcing you or threatening you to make you admit the violations?
No, ma'am.
Yes, sir, Mr.
Your Honor, just for the record, the Public Defender's Office did obtain a confidential evaluation through a licensed professional, and I'm just putting that on the record. I did consult about that with him, and it did not show a basis for our raising an issue that would prevent him from pleading out today. Thank you.
Okay, thank you.
You understand?
Yes.
Has anybody promised you anything to make you admit the violations?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
I have a score sheet, and it shows 43.8 total sentence points. Any objections?
No, Your Honor.
Right. And Mr. Dove, did you look at the score sheet?
Yes, ma'am.
Okay, and did you see how your attorney had made the corrections on it?
Yes, ma'am.
Do you agree with this score sheet?
Yes, ma'am.
Are you admitting the 2 allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made in accordance with your agreement. The court does find you guilty of violating your probation. It looks like there was already an adjudication of guilt on the charge. And probation will be revoked and terminated, and you'll be sentenced in accordance with your agreement to 11 months and 29 days in the Okaloosa County Jail with credit for all time served. And the following additional fees and costs will be imposed. $100 VOP cost of prosecution fee, $150 cost of defense. That includes the $50 application fee. After you get out of jail, you'll have 1 year to pay off all of your fees and costs before they go to collections. And once they go to collections, that'll probably suspend your driver's license. So if you need more time, go see the clerk and ask about a payment plan. All right, you'll have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck, sir.
All right,
Thank you.
Thank you, Your Honor.
Thank you.
Hamilton Boykin.
Do you mind handling it?
I gave him a copy.
Good, good.
And the only, I just put 10, for some reason, typo. That's the only, like, handwritten I put in.
Got it. Yeah. I'll make sure I say it. Well. When did you get that? You mean they read when you were here 2 weeks ago? Okay, well, let me refer. Your Honor, Steve Medina with Hamilton Boykin, 24 CF 356, 24 CF 356. He's before the court on a VOP. Mr. Koch has kindly drafted the VOP agreement. When I think we have an agreement, it's 10 months Okaloosa County Jail. He's raising 2 issues relating to credit for time served. It is a credit for time served deal. And I explained to him that I would also mention that it's all time served that he's entitled to. So just because the word all was omitted didn't imply that he didn't get credit for all his time served to which he's entitled. The second thing is that he advises, I'm sorry, Judge, let me get the right file.
Okay, and I believe Mr. Ferris is going to want to be heard on something, but I don't know what, but he appears to want to be heard, so.
Yes, James Ferris for Rachel Gaynor for the state. I'm reading Ms. Gaynor's notes. It is a stipulation with respect to credit for time served for this VOP.
Okay.
there is not, the state is not granting to credit for time served with respect to any previous VOPs.
Well, is the state asking him to waive his credit from prior times before the court? Because that isn't what one would normally do. So I need clarification. He appeared, it looks like in his file, he did a Haven House deal, bars to bed, on a first VOP, which was June 17, 2025. And as that part of that deal, you know, he had to go to Phoenix House. He had to go to Haven House. And then he allegedly violated the Haven House, and then we're resolving that now. So is the state saying that its offer would require him to waive credit from June 17 and prior? Because that would not be a normal, you know, request, basically. But I'm not saying the state can't request it. It's just, that was not my expectation. It wasn't his expectation.
Yeah, I can't represent what the communications you may have had with Ms. Gaynor, but the notes that I've got is with respect to this VOP. That's the credit for time served. So that would be, yes, waiving any time for credit for time served prior to the arrest for this VOP.
Okay, so the state, appreciate the clarification. So Mr. Boykin is indicating he doesn't want to take that deal. My
Okay.
job is not to
Understood.
pressure and so forth. So at this point, because this is now the second time up, I'm concerned it's dragging. It doesn't seem like he is going to be reaching an agreement for a resolution. I think it probably needs to be set for VOP evidentiary so
Okay.
we can bring it to finality. Obviously, and as the court's well aware, in, for instance, Escambia County, they don't do VOP deals anyway. Basically, you're either found to admitting, or you're found to have committed the violation through an evidentiary hearing, and then it just goes, it's an open plea, basically it's an open sentencing decision of the court.
Yeah,
So-
let me put it in more blunt terms. It's my understanding that agreements to resolve violations of probation are unusual in certain other counties. And I've been in 3 counties now. So I do take most agreements on violation of probation cases, but, you know, that's not the case everywhere.
And then they're basically, just so because he is before the court now, and this raises, I'm on the cuff here addressing some technical issues, and Mr. Koch, having been to law school this millennium, probably has better and more up-to-date information, but basically credit for time served is an issue that we're going to need some clarity about. He'll need some clarity in making his decision. My assumption is that when an agreement says credit for all time served or credit for time served, it would have included the all time in this case from prior incarceration. And so in other words, if he's found to have violated and he goes to Your Honor, then Your Honor will be exercising the court's jurisdiction to sentence him, and generally speaking, you get your time served. So when you get your time served, generally speaking, there is a question of law. Maybe the state is disagreeing as to whether that would include the prior credit from the prior VOP. It normally would include that. So I just wanted him to know the court would normally give credit for time served. Can the court clarify Your Honor's policy, and or is there any statutory
Whatever
advice?
deal y'all might work out, I don't get involved in negotiations.
Well, I'm not asking for
Yeah,
that.
oh, I know, I'm just, for Mr. Boykin's benefit, I don't get involved in negotiations. I just the deal is presented to me, and most of the time I will ratify the agreement. There have been times I've rejected agreements, but, so if there is some sort of agreement about credit or not credit, that's between the parties. If this were a plea straight up, then the court would be bound to give all credit, is my understanding. So that is not any type of promise of any particular sentence. I'm just, I'm just saying that I would not have the authority to waive someone any type of credit. The credit is what it is if I'm the one that's sentencing without an agreement
And
between
just
the parties.
so we're clear on what he's before the court on, my understanding is he was before the court on one third-degree felony.
Correct.
I apologize to my colleague for putting
Correct.
on the spot. I want to make sure we understand. It was for a felony DUI, I guess third conviction within 10 years.
That's
Third-degree
correct.
felony with a 5-year max, $5,000 fine max, no minimum mandatory.
Correct.
So basically, if your honors, if we don't go with a plea, your honors jurisdiction would allow the court to sentence him to up to 5 years DOC.
That's
And there would
correct.
be if you don't have an agreement, there's no agreement, and the court could go up to the statutory maximum. Not
Credit.
saying, then the
Yeah,
court's not
credit.
giving any guidance on what the court would or might do. So all jurisdiction is available
Yeah.
to the court.
That's
So
right.
we don't have an agreement. I think it
It's
needs to
fine.
be set for VOP evidentiary.
I've got dates, so we could do that now. So here they are. And I-
You
yeah.
wanted to ask me a question.
Yes.
Respect, I'm not going to go into our attorney-client, but I've given him some feedback.
Okay.
But I can't do anything more than get it set for VOP evidentiary, I think.
All right, so here are the dates. We have April 16th. Does that work? If that one doesn't, then I'll go on to the next one.
I'm
Yeah.
here whenever your honor tells me, your honor.
I'm looking at dots, so if you could just give me half a second.
Sure.
Perfect, is the odds, yes, that April 16th.
April 16th. I've already set one for 9 o'clock, but I'll just set this one for 9 o'clock as well.
Yes, your honor, in the event
We'll
of
double book
a-
it. Yeah.
Sorry, Your
No,
Honor.
I'm just going to double book. That's fine.
So in the event that Mr. Boykin, because this will give him something to think about, I'll come and meet with him, but I am putting on the record, in the event that the defendant makes a decision freely and voluntarily to admit, if he wants to let me know that doesn't mean that we won't need the hearing, because he
Right.
still could have a hearing and present his brother, for instance, and talk about the
Whatever.
nature of the sentence and asking for a certain kind of sentence or whatever, but anything could happen up to the statutory maximum of 5 years DOC.
So everyone needs to be prepared to go forward on that date.
Right.
Whatever y'all decide to do is up to y'all, but there will be a resolution on that date. That's just what I mean, either it's going to be an agreement or it's going to be a contested hearing. And if there's a contested hearing and if there's a finding that there is a violation, then I would proceed to sentencing that day.
Does it, ma'am, the only other thing I can ask for his consideration in the ensuing month, does the state, well, Ms. Gaynor's, it's Ms. Gaynor's case, so I know Ms. Ferris can't, but it would be good for him to know what the state's offer would be, if it's anything different than, basically right now, the state's best offer would be 10 months jail with credit for all time served, but waiving prior credit that's time served subsequent to June 17, 2025, when he did his prior BOP hearing. So if it's, would the state keep that offer open if he were to decide to take it?
Keep it open until,
Is there any
I
kind
mean,
of...
that's not gonna be the state's offer if there's an evidentiary hearing.
I'm just trying to pin it down. Do we have any...
If there's an evidentiary hearing, then then I would make the decision.
I know, I'm
So,
just...
assuming if there's a finding of guilt.
I understand. So basically, the drop dead date on taking the 10-month deal and waiving the prior credits from June 17, 2025 and before is right now. Because otherwise, your next court date, next time to come to court is going to be April 16, 2025, and I can't say what's going to happen. I certainly can't say what the judge would do. The judge isn't saying what she would do, so.
Well, yeah, I'd have to hear the evidence.
Yeah, of course you are. I mean, that's disrespect.
Oh, I know.
It's,
Yeah, subpoenas are not out, so I'll speak for Ms. Gaynor and say that offer is open until the end of the week.
till the end of the week.
Till the end of this week, yeah.
Okay. So, could we do this, Judge? I'm sorry, Judge.
Oh, that's okay. What?
I hate to beat a dead horse here, but could he come back on the 19th, 2 days from now, and do it then?
Is that what you want to do, sir? You want to come back and, you want to think about it for a couple of days and then, okay.
That way he'd actually, before the end of the week, have a chance
Yeah.
to do the deal.
No one wants to pressure you to do anything. So do not feel bad if you come back on the 19th and there's no obligation to you to make any decisions. Do you understand that?
Sure.
Okay, I don't want you to feel like you're pressured or rushed or anything in making a decision just because we're going to set you in 2 days.
And Judge?
Uh-huh. So let me add Mr. Boykin to the 19th. That's in 2 days.
Thank you.
Sure. March 19th we'll add Mr. Boykin to the 9 o'clock docket that morning.
And just, I
Okay.
have to put one other thing on the record.
Sure.
It doesn't get easier for him, but basically, he's representing that he, subsequent to June 17, 2025, that he may have done, I don't know if that's true or not, but basically that he did some time in Walton County Jail prior to being booked on the VOP.
Well, that wouldn't count.
That would not count.
I mean, because that's on a different case, right?
I'm not sure. He might have been, if he was arrested on this count, but not booked until he got to,
Oh.
I don't know.
Oh, well, I don't know.
Because you basically, if they picked him up in Walton County on this VOP, because it was, I think Haven House maybe in Mirror Beach or something, but did they pick you up in Walton County and you go to Walton County Jail?
May I speak?
Don't talk about the facts of the case, but did you go to Walton County Jail
Yes.
on this VOP?
No.
In this county or not? there's some very complicated.
No problem. So do you still wish to set the case for Thursday morning?
No, Your Honor,
Okay, so we're not setting the case for March 19th, right?
No, Your Honor, he's saying at this time that he wants to go ahead and take the state's offer. What I cannot advise him about is what his time served would be subject to, subsequent to June 17, 2025, including but not limited to as to any time he spent in Walton County prior to booking here would probably not be counting toward this case. I don't know what he did jail in Walton County for, but it sounds like it wasn't on this VOP, but I don't know. I just don't want him to say, well, Medina didn't tell me what about Walton County. So.
Well, I can tell you that the warrant in this particular case was not even issued until December 31st. And so then it says served by email to Okaloosa County Sheriff's Office warrants. That wasn't even sent to, I don't think it was sent to Okaloosa County Sheriff's Office until January 6th. So if there's credit prior to then, I mean, the warrant wasn't even issued yet. So.
Well, he's saying something about an FTA, and I don't know anything about an FTA. So.
Okay.
I just can't research on the fly things I don't know anything about. So. I don't know what your time served would be. The way the normal course, Your Honor, just for his consumption, is that the Okaloosa County Jail time served officer does a memorandum of your jail credit. And it's usually correct. Sometimes there are mistakes, but the law is that you're entitled to all the credit in this case. And it usually runs from when you're booked on a charge or a VOP relating to this case. If you did time in Walton County prior to booking in this case, it wouldn't count.
Okay. And then.
Is that what you want to do?
He was served with the warrant on January the 9th.
Go ahead and sign it. No, this is going to count. I'll go ahead and sign it.
You're going to end up doing, how long have you been at Okaloosa County Jail?
Probably 2 months.
He was supervised by our office by Officer Keene, and he was picked up on his warrant in our office in January for the week because he left Haven.
So you got picked up in your office in Fort Walton Beach?
Yes.
Okay, so probably the only credit you're going to get on the 10 months is from that day when they picked you up.
Okay.
Okay?
Okay.
So which was January, we're now March.
Okay.
Okay, so you're going to do like roughly 8 months jail or something, give or take. That's the state's offer. Do you want to take it?
Yeah.
Can I see the attorneys at the
Sorry,
bench for a
Ben.
second? That's okay. All right, so Mr. Boykin, I think it's best if you have more time to think. So
Yes, ma'am.
we've got you scheduled for March 19th, that's in 2 days,
Yes, Your Honor.
for a status. There's no pressure on you to do anything. That is at 9 o'clock, so that's Thursday, this Thursday, at 9 o'clock. We've still got the April 16th hearing scheduled, that's April 16th at 9. So that's scheduled, that's on the books as well. And we'll see where we stand. You may think of more questions between now and then that you want to talk to Mr. Medina about, and you'll have more time and you won't feel pressured to do anything,
Well, just for
okay?
the record, Judge, I
Not
won't
that
be
you're being
seeing him
pressured.
at the jail.
Right.
I'll only be seeing him back here, but he's had
Yeah.
benefit of the things I've said on the record today, and I'm giving him the agreement so he can look at it and think about it.
Yeah, because I can see that, that you're under a lot of stress, and I don't want you to feel rushed into making any decision, okay?
Thank you, Your Honor.
All right, we'll see you on Thursday morning, Mr. Boykin. And then there is one other case. Did we cover all of the inmates?
Yes, sir.
Okay, great. So there's one other case that is not on the docket, but it should have been on the docket, but for some reason it didn't make it to the docket. And it's 21 CF 2328, and that is Jeffrey Crunk, Crunk. And Mr. Medina, I believe that's your,
Yes, Judge, I didn't notice that until about an hour ago, that he didn't transport. I do think that he does need to get in here on